Good afternoon, delegates and panelists. I'm happy once again to welcome you to today's training session. It's day 6 of Legal Aspects of Finance Overview, Issues and Documentation. I'm sure you would have found the previous trainings very enlightening, and I indeed hope that you enjoyed today's training. Today we'll be having a session on Islamic finance, which again, an aspect of financing that's becoming very, getting a lot of currency now. And I expect that you will find today's session illuminating also. So today's speaker or trainer would be Masood Balogun. Masood is a leading lawyer in the Islamic finance space in Nigeria. His experience cuts across corporate law, corporate finance, capital markets, dispute resolution, and Islamic finance. Masood played a leading role in structuring the first sub-sovereign and sovereign sukuk in Nigeria. He has advised issuers on structuring documentation and Sharia governance of Islamic finance products, including sukuk, mutual funds, and exchange trade funds. Masood has collaborated with financial regulators to draft review regulations in the Islamic finance space. He facilitates trainings for capital market operators and has championed various market leading initiatives in the Islamic finance space. Masood is the company secretary and legal advisor to Lotus Capital Limited, the pioneer firm in Islamic fund management in Nigeria. He's also a member of the Securities and Exchange Commission Committee on the 10-year master plan for the non-interest capital market. It is my pleasure this afternoon to welcome my friend Masood. Masood, the floor is yours.
Thank you very much. Good afternoon, everyone, and welcome to this very important training program of the NBA. I'd like to commend the NBA for this initiative of training lawyers and giving lawyers access to learning about practical aspects of finance and legal documentation. Without much ado, I will start the business of the day, which is introduction to Islamic finance. So what we'll be doing in this session is to give ourselves an overview. It's impossible to cover all the field in or all the different aspects in about an hour or so, but I believe our takeaway from this session will be to have a general idea or overview, as it were, on legal aspects of Islamic finance and what it is all about. If you are hearing it for the first time, Islamic finance is also called non-interest finance in Nigeria. Different countries call it different names. Some countries call it profit sharing finance. Others call it Islamic finance. And in Nigeria, when you hear non-interest finance, is similar to Islamic finance. In this class, part of the learning objectives that we have is to gain a proper understanding of the non-interest finance principles, to also understand the breadth and depth of the non-interest finance industry, and to also have an idea or overview of contracts that are used in Islamic finance, which I believe is the most important for lawyers like us. So in terms of how we would proceed, so we'll first of all go through an overview of Islamic finance, and try to introduce ourselves to the subjects, and now run through the concept one after the other. So first of all, a background. So the non-interest finance system is an alternative form of financing to the conventional mode of financing. But what is different is that the non-interest finance derives its inspiration and principles from textual teachings of the Abrahamic religion. So if you look at non-interest finance, derives its teachings or its inspiration from both the Muslim religion and the Christian religion, as well as the Jewish religion. So which are the three Abrahamic religions. We know that, and we refer to textual provisions in that regard. In Deuteronomy, for example, we have the verse, Deuteronomy 23 and 19 to 20, say, thou shalt not lend upon usury to thy brother, usury of money, usury of victuals, usury of anything that is lent upon usury. So if you are a believer, you will relate very well with this, in the sense that what the text commands us is against lending based on usury. So no, you should not lend on the basis of interest. Then in Quran 2, verse 275, it says that uh, trade is like interest. People that do not understand the difference between interest and trade, when they were forbidden from lending on the basis of interest, they retorted that, look, what is the difference between interest and trade? When I sell something to you and I get profit from it, is the same thing as interest. And people still suffer from this confusion till date. Even practitioners, when transactions are structured, they will tell you that, oh, when you engage in this transaction and you give a straight loan, they are the same thing. What is the difference? So if you are confused about the difference, you are not alone. Right from time immemorial, people that have also been told not to charge interest or lend on the basis of interest have also retorted, what is the difference? So Quran 2 verse 278 says that, "O you who believe, fear Allah and give up what remains due to you of interest if you should be true believers." So these are some of the verses in the Quran that prohibit the giving and the taking of interest. And we'll see how interest and trade and all that operate in commercial sphere. So the overall objective of non-interest finance is to promote an ethical and justice-based financial system that contributes to overall economic development. So the objective is not to just focus on earning interest or earning profits, as it were. It is to ensure a financial system that protects and attends to the interest of all and sundry. So the certain concept that we would come across here is that the non-interest finance system, or the Islamic finance system, if you like, is clear about its prohibition of interest. However, it also advocates for profitable investing and overall economic growth. Beyond this, beyond the prohibition of interest, non-interest finance is also guided by some fundamental principles which distinguish it from a conventional mode of financing. We'll see that in other non-interest finance, for example, there are certain areas that we cannot invest in. So areas like adult entertainment, arms and ammunition, uh, um, production of alcoholic beverages, gambling, and all these areas. These are areas that Islamic finance will not support investment in, while in the conventional aspects financing, they are quite neutral. What is most important is the business model that you are running. Once the business model is fine, it is irrelevant to a typical conventional institution where you deploy these finances. Of course, in recent times, we have seen discussion about social responsible investing, which is what's part of the key drivers of Islamic or non-interest finance, which is to say that we should invest in areas that promotes justice in the society, that promotes economic integration, that promotes empowerment, as opposed to investing in areas that promote vices and all that. So there are companies, for example, or hedge funds that have sort of say, we will not invest in certain sectors. So, and they are not driven by any form of faith consideration. They are just driven by social consideration to say that these are red flag areas that we are not going to invest in. So you will see that aspect of social responsible investment in Islamic finance as well, because part of what non-interest finance is preaching is that we should invest in areas that promote justice, that promote economic integration, that promote morality, and we should not invest in areas that typically harm the society. So our objectives, apart from interest, should not just be earning money. You know, our objective is also to promote social integration. So some of the fundamental principles are as follows. So prohibition of usury. So usury in simple terms is an excess or any unjustifiable increase in capital, whether in loan or in sales. So when you charge excessive return, when you want to earn excessive return, that is termed as usury. When you also give out loan, and irrespective of the performance of the underlying business, you want a predetermined sort of return, that is also referred to as usury. So that is prohibited under non-interest finance principle. One other objective or principle is risk sharing. This demands that providers and users of capital, they should share the risk. So if the business is not doing well, don't behave like Shylock and say, look, it is none of my business. So Islamic finance or non-interest finance or faith-based financing will tell you that your return should be linked to the performance of the underlying asset. And where there is a default due to the risk environment, then providers of capital should also share in that risk as well. So another principle is money is viewed as potential capital. You know, money is not viewed as not viewed as being that is capable of automatically generating return. Money is viewed as a potential source of capital, meaning that if you deploy it to profitable purposes and it yields profit, then you can share in return. But if it doesn't yield profit, you should not just say, oh, I will get my capital irrespective of the performance of the underlying business or assets. Then another principle is prohibition of speculative behavior. So when you engage in speculative behavior in such a way that it drives or it puts the market on overdrive. And we see this a lot in stock trading. So while stock trading is allowed, but even in our Investment and Securities Act, speculative trading and all that, it is something that is also prohibited. So attempts or any activities that sort of manipulate the market and drive price above their real value is something that is also prohibited under the ISA. So you'll see that there is an alignment between non-interest financial principle and even commonsensical principles of financing. So speculative activities are prohibited because at the end of the day, they just harm the society and they do not promote economic development. So another fundamental principle is sanctity of contract. So your word should be your bond. And you see in a society where contracts are easily breached and you cannot trust the performance counterparties to perform their obligation under a contract, you will see that we will not have a viable financial system. So that is also what Islamic finance is preaching, that contracts are sacred. Once you sign a contract, you should honor it. Then another aspect of it is permissible / social responsible activities. And we've touched on this earlier to say that non-interest financial principles lend itself to social responsible investment, such that we do not invest in areas that are detrimental or injurious to the society. So once we bear all these principles in mind, it permeates all through our activities under the Islamic financial system. So just some historical background. I mean, modern non-Islamic finance, although it is rooted in scriptures, in the development of Islamic finance into a system is something that is recent, within 50 to 60 years ago. Started in Egypt and spread across Middle East, Malaysia, Southeast Asia, and all that. And it has continued to develop over time. And what we have found as well is that financial systems that are rooted on the principles of Islamic finance, they may not necessarily call themselves non-interest or Islamic finance, but once they adopt those principles that are espoused by Islamic finance, they tend to withstand financial crisis more than financial systems that are just based simply on conventional financing. And we saw that during the last global financial crisis, because most of all these Islamic financial institutions, they were built on assets, they were built on profitable business, they were built on socially responsible business, and they sort of, they were able to withstand that challenges more than other systems that were not based on those ethical or strong fundamentals. One thing we should also note is that, if you are hearing Islamic finance for the first time, is the fastest growing in financial industry in recent times, and that is understandable because it's new. It is getting more embrace within the financial system. If we look at 10 years back, when Islamic finance was introduced by when the Central Bank of Nigeria, first of all, enacted the regulation on non-interest finance, it was something that was novel or strange in the system at the time. But over time, we've seen the development of and the adoption of non-interest or Islamic finance principles across the financial institutions, and it continues to grow, and we'll reel out some of the statistics. So, the statistics is to enable you to understand the relevance of this aspect of finance and why you should know it or key into it, such that in your practice or in transactions, when they are brought before you, you are able to contribute effectively. So again, this is talking about the non-interest finance industries and why it is a very sustainable mode of financing. So areas such, because it focuses on risk sharing, liquidity management, and all that. It sort of gives that focus of the industry to risk sharing, profit sharing, and all that, sort of makes it sustainable when compared with other form of financing. And we're still talking about the crisis and how it was able to withstand the crisis at the time. So I won't spend a lot of time on that. So in terms of the industry breadth, so it has grown over the years. It has covered banking, insurance, money markets, and capital markets as well. So it's something that is expanding day in, day out, and new innovations are brought on board to cater to the new challenges. Remember that I recall that I mentioned that Islamic financial system as an organized form of financial system is something that is recent in the last 60 years or so, although the concept has been with us from time immemorial, from the Abrahamic times, where it was declared in the scriptures that you should not charge usury and it should not support the certain kind of activities, So when we break it down, so we have the banking sector, and we've seen a number of Islamic banks or non-interest banks in Nigeria now. So whether in the retail, in banking, you can also subdivide it into retail and corporate banking, microfinance. So there's also central bank regulation on the licensing of microfinance, non-interest microfinance banks, just as there is on licensing of full-fledged Islamic banks. There's also Islamic windows of a conventional bank, and we'll see that down the slide. So another sector is capital market. So we see that in asset management and issuing houses. So we see fund managers that are managing funds that are specifically focused towards Islamic investment. They do not invest in any other aspects. They only invest in Sharia compliant or non-interest investment. So we also see issuing houses who are sort of package deals based on Islamic finance principles. So the sukuk that you send in the markets, whether the federal government sukuk or state sukuk or private kind of sukuk, they are packaged by each issuing houses with expertise on Islamic investment. In the insurance industry as well, we'll see takaful operators, re-takaful, which is like reinsurance, and a micro takaful or micro insurance as well. So we've also seen operators in this field packaging products that align with non-interest principles. So we'll see that across the financial chain, we see this play out. We see non-interest Islamic financial services being offered in banking, in insurance, in pension, and across the financial services sector. So it is very critical that as a practitioner, you be aware of all these activities. So mutual funds, bonds, mortgage. So banks lend or provide mortgages based on Islamic financial principle. They finance assets based on Islamic financial principles. There are equities that are also compliant with Sharia principles. Insurance, family takaful, and all that, like we mentioned, it cuts across industries and the products are different, So as I mentioned, it's important for you to be aware of this product and the services so that you can deploy your expertise to assist practitioners or market players to develop it appropriately. So in terms of relevant standards, so what we should note is that in the regulatory landscape is that all investment laws or all financial laws that are in operations in Nigeria, they also apply to non-interest finance. So it is not as if it is immune from the application of the relevant financial regulations. So the Investment and Securities Act, for example, would apply to investment products. The Banks and Other Financial Institutions Act, the BOFIA, will apply as well to a non-interest banks. The PENCOM regulation or the rules of the Securities and Exchange Commission and all financial laws generally, the Insurance Act, all financial laws generally also apply to non-interest financial activities or operation. So in addition to that, there are specific regulations that have been made to cater to the specific needs of the non-interest sectors. So, for example, the Securities and Exchange Commission has, as part of the rules on Islamic fund management, rules on sukuk issuance, for example. So those are the things that we should pay specific attention to. The Central Bank of Nigeria in the banking sector, for example, also has guidelines or framework on non-interest or non-interest principles or different aspects of non-interest finance. So the PENCOM also has regulation on investment in Islamic finance and all that. So there are specific rules or guidelines that have been made by the regulators to cater to non-interest finance. But the general regulation or general laws that are applicable to banking, investment, pension, insurance, and all that applies to non-interest financial services and products. So we should bear that in mind. In addition, there are certain other standards that applies to non-interest principles. So one of it is the IOFI standards. So is the accounting and auditing. IOFI stands for the Accounting and Auditing Organization of Islamic Financial Institutions. So they've developed some standards to sort of guide the operations of Islamic financial institutions. While IOFI standard is widely recognized, it is not generally domesticated by any jurisdiction to say, no, this is the only standard. No. So it's just act as a guidance to a number of financial institutions, and it is a reference material when dealing with Islamic financial institution transaction. So another standard is the IFSB, which is Islamic Financial Services Board. It is based in Malaysia. It's also a standard setting organization. They come out with rules, accounting standard, and the auditing standard, and all that to guide the preparation of account statement of Islamic financial institutions or specific areas of Islamic financial institutions. Another relevant aspect is the local regulatory bodies. I mentioned earlier that the Central Bank of Nigeria, Securities and Exchange Commission, the insurance regulators, PENCOM regulators, all of them, they've all come up with one rule or the other to deal with specific areas of Islamic finance. And again, one unique aspect of Islamic finance is the presence of Sharia board for each institution. So the Central Bank of Nigeria, for example, requires every bank or microfinance bank that is operating in the Islamic finance space to have a Sharia board. So what does this Sharia board do? They act as first level review before the regulatory approval. They review the contracts that will be adopted by the financial institution to ensure that it is compliant with Islamic financial principles. And at the end of the review of the contract, they issue a certificate to say that this transaction or this contract is compliant with Sharia principles, and it is those contracts that will be used by the financial institution to enter into transactions with counterparties or with customers. So for the banks, it is called Advisory Committee of Experts, or ACE, Advisory Committee of Experts. While for fund managers, it is flexible. You can call it Sharia board or Sharia supervisory board and all that. But it's a requirement both by the Central Bank of Nigeria and by the Securities and Exchange Commission, as well as the Insurance Commission, for every Islamic or for every institution offering Islamic financial services to have a Sharia board which certify that their products and services is compliant with non-interest principles. So other relevant bodies are, we have the Islamic Development Bank, which is based in which is based in Jeddah. So it is a development bank that is tilted towards Islam, operating in a Sharia compliance manner. Nigeria is also a member or an investor in this Islamic Development Bank as well. So we also have the International Islamic Financial Market, which is also, a standard, a form of standard setting institution, and it also offers products and services that are Sharia compliant. So the International Sharia Research Academy for Islamic Finance is also another body you should be aware of, and they offer, research materials on different areas of Islamic finance. So articles and all that, you can find them there. The OIC Academy is also a very important regulator or player in the Islamic finance space, in the sense that they issue pronouncement from time to time on different areas of Islamic finance. So the General Council of Islamic Banks and Financial Institutions, the International Islamic Liquidity Management Corporation, those are some of the key players as well. I'll just move so we do not spend too much time here. So this still talking about the growth of Islamic finance. The top 10 countries are Malaysia, Bahrain, UAE, Oman, Pakistan, Saudi Arabia. And you've also, in recent times, you've also seen Western countries joining. The UK, for example, is quite big on Islamic finance. Germany is also big on Islamic finance. Luxembourg is big on Islamic finance. So you see, just talking about how the growth of the industry and why it is important for you to be aware of this industry. And you see big top law firms, the Clifford Chance, the Allen and Overy, and Norton Rose and all that. They have specific desks. That's internationally, and locally as well. We have a number of top law firms who also have specific desks or department that deal with Islamic finance. We talked about so the operators in the industry. So we have full-fledged Islamic banks. We have window operations. So in the full-fledged Islamic bank, you have the Lotus Bank, the Jais Bank, the Taj Bank, and all that. You also have window operators. The CBN recognized that conventional banks that can have a department within them which sort of operates Islamic financial services. So you have Sterling Bank, for example, which has window operations. So you have Takaful. Takaful is another name for insurance. So you have Takaful operators, the Nuru Takaful, and I think Alliance as well offers Takaful products as well. So under its window operations. So you also have capital market operators. So you have the companies like Lotus Capital, who has just focused on Islamic finance fund management. You also have other operators who have funds that are focused on Islamic fund management. The First Bank, for example, has a fund that is focused on Islamic fund management, and Stanbic as well has fund that is focused on Islamic fund management, among others. So you see it across the length and breadth of the financial services sector. So listing out some of the regulators that you find: the Central Bank, the Securities and Exchange Commission, the NSC has listing rules that is specific to Islamic finance. The FMDQ also has listing rules that cater to Islamic finance. So you have the National Pension Commission. You also have the Nigeria Deposit Insurance Commission, which is a insurance deposit institution. And because it regulates banks that offer Islamic financial services. So it also had to keep sort of a separate fund or give or provide a deposit insurance for this Islamic financial institution. So you see it across the length and breadth of the financial services. So again, I mean, the key drivers, as we mentioned earlier, the ability to boost financial inclusion, so ability to attract foreign capital into the country, and to enhance productivity and competitiveness in the market. So I think I have about 30 minutes or so that will run through the non-interest financial contract, which I think is very critical to this our introductory class as well, because I mean we've learned in the first session we learned about the importance of this industry and the relevance of the industry and why we should be involved and be aware of the activities of these industries. You know, and we see all the players, the regulators, the operators, and all that. So now let us talk about the contracts. So there are um, three or four different types of contracts that you will find in Islamic finance. You know, so the first is profit sharing contracts. The second is lease sharing, lease based contracts. The third is deferred delivery contracts. Then the fourth is a markup contract. I will go through them one after the other. Yeah, so the fifth is not a type of contract really, just supporting contract. So that's where you find guarantee and all those kind of contracts. So starting from the profit sharing contracts, you know, so we mentioned that it utilizes four key contract structures. So you find different variations here and there, but most of them can be categorized under four kind of contracts. If you like, you can even divide it into two. So if I want to divide it into two, you see one that is debt-based and one that is equity-based. Debt-based and equity-based. So debt-based, you find a markup contract or lease contract under debt-based. And equity-based, you find profit-sharing contracts or investment management kind of contract under the debt-based, under the equity-based kind of contract. So that's if you want to divide it into two. But we can let's work with four divisions, you know. So and here, so we have profit sharing. We talked about musharaka and mudaraba. I will break it down in subsequent slide. In lease-based contracts, we talk about ijara. Then in cost plus contract, we talk about murabaha. We also then in deferred delivery contract, we will talk about salam and istisna. So, but the most common type of contract are the ijara and murabaha contracts. The ijara and the murabaha contract, and you will see that for banks, more than about 90% of their transaction is based on the Murabaha contracts. You know, based on Ijara contracts, lease, particularly for, if you see Sukuk in the market, the Sukuk that has been issued by the federal government of Nigeria is based on Ijara, which is lease. But in terms of banking transactions, most of them are based on Murabaha contracts. So in your interaction with banks in relation to Islamic financial services or contract, more often than not, you see this Murabaha contract and less often Ijara contracts, while Musharaka contracts and Mudaraba contracts are rare. So, but we'll still go through them, notwithstanding, to sort of have an idea of what each of these contracts entail. So we start with profit sharing contracts, right? So you hear the language musharaka. It just means profit sharing. So musharaka means a joint enterprise formed by the contribution of capital by multiple parties. Profit on the enterprise is shared on an agreed ratio, while losses are shared based on the percentage of capital contribution. So look at it as an unincorporated joint venture, So we want to we want to develop a property, for example. There are 10 people, the development will cost 100 million, and each participant contributes 30 million, and they can agree that the profit would be distributed among themselves on the basis of their contribution. So everybody will get 10% of the profits. So that is what a musharaka is, more like an unincorporated joint venture. The parties can also agree, for example, that the profit sharing ratio can be different, So one person can say, notwithstanding that they contributed the same amount, their profit sharing ratio can be different. So one person can take 10%, another person 15, another person 5, another person 7. So there is that flexibility to divide the profit ratio in accordance with the agreement of parties, right, under a musharaka. But what is key is that losses will be borne according to capital contribution. So if you contributed 10 million, if there is a loss, your loss will not exceed 10 million, losses has to be borne in accordance with capital contribution of the participants, So again, here parties share risk, which is a fundamental principle of Islamic finance. Parties share the risk. If there is a loss on the project, parties will bear it, and there is no guaranteed return for any particular partner in the project, So it's an ideal alternative to the interest-based contract, So where banks want to provide financing for a project, they should also consider having taking a risk in the project itself, and not just lending to the borrower at a fixed interest rate. So usually the bank will ask the customer to provide an equity contribution, which is to ensure the customer has a stake in the project. So the bank can also take a risk on the project by being an equity holder in that joint venture, as opposed to just a mere lender. So it's as I mentioned, it's an alternative to interest-based lending. So this is like a structural diagram of how a musharaka works. So there's a partnership in capital. So there could also be partnership in services, meaning that one of the partners can be a managing partner, for example, or you can a form of musharaka is for two parties. For example, a law firm, when there is a partnership being formed by a law firm. So each of the partners want to contribute their services to the business of the law firm. So there can be partnership in services as well. It can also be partnership in capital, meaning everybody provides capital, or partnership in services, or partnership in goodwill. So when one person is starting a business, another person's contribution can just be their goodwill. And the Kama requires, for example, that you should value that goodwill in monetary terms, so that you can know the actual contribution of that person to the partnership. So there can also be partnership in purchase and all that. So different forms of partnership here and there. So in a typical financing arrangement, you see that the non-interest Islamic financial institution, which is what NIFI means, the non-interest financial institution and clients enter into a musharaka agreement and fixed profit sharing ratio. So the client will manage the business because it's the client that understands the business, and profits are shared according to agreed ratio, and losses are shared according to capital contribution. So, and this is typically used in mortgage transactions, where the Islamic financial institution and the mortgagor, they sort of provide capital for the building or acquisition of a property, and the mortgagor leases, so they both own the property, right? So the mortgagor leases the portion that is owned by the Islamic financial institution and pay rental for the lease from the Islamic financial institution. But in terms of the acquisition, they partner together to acquire the property. So it can also be for project financing, for example, where different parties, whether companies or financial institutions, they come together to develop a project, and it can be a road, for example. So if different institutions come together to build a road and they toll that road, and profits or collection from that road are used to both maintain the road, and any excess is shared among the institutions as profit, So that is also a way that this works. So it's an unincorporated joint venture, just a simple way to look at it. So other features, partners have the right to appoint agents and be appointed as agents. So one of the partners can be a managing partner in the project, So any form of liquid, so in terms of capital, any form of liquid or illiquid assets, so not debt. So what you be contributing to the project will not be a debt, so you can't net off against debts so that is owed to you as a contribution to in a musharaka. You have to bring something, whether it is a liquid capital or illiquid capital. So then business, the nature of the business has to be permissible, So I mentioned earlier that one of the key distinguishing factors of non-interest finance from a conventional finance is also the focus on the business, So you cannot do a musharaka for gambling, for example, or for production of alcohol beverages, or for the operation of adult entertainment industry, or things that are generally prohibited under non-interest or Islamic principles. So another aspect of it is profit sharing, So there is no absolute amount. You cannot say I'm going to earn XYZ% definitively on the project. No, it is based on the outcome of the project. So if the project yields return, partners will share in accordance with their profit sharing ratio. And if there is no return or if there is a loss, they will bear in accordance with their capital contribution. So another aspect is the contract. The language of the contract has to be clear and precise. No speculative or ambiguous language in the contract as it were. So similar to musharaka contract is mudaraba. So the first is musharaka, the second is mudaraba. So a mudaraba is a business partnership between two or more parties. One party provides capital while the other provides the investment management expertise. So if you compare it with the musharaka, everyone provides capital, While in Mudoraba, it is only one party that provides the capital, while the other party provides the expertise. So look at it from the aspect of fund management, for example, which is what is largely used by fund managers. So the investors provide the capital, while the fund manager provides the expertise. In banking transactions, for example, the bank will provide the capital while the client will provide the management, because it's the client that understands the business. So here, risk and reward are shared. In the case of a profit, both parties receive their agreed upon share of the profit. So the profit sharing ratio can also be anything. You can say the manager will get 80% of the profit while the investor will get 20, or the other way. Whatever profits sharing ratio you agree on is quite flexible in that regard. But in the case of a loss, only the capital provider will bear the loss. Only the capital provider will bear the loss of the capital, while the investment manager is only the only loss that will be borne by it is the loss of ability to earn profits and loss of time and resources that it has deployed towards trying to generate profit. But in terms of the capital, what's it called? The investment manager will not lose anything, will not lose its capital. So the investment manager will not be obligated to provide a guarantee for the investor. So of course, there are risk management mechanism to sort of guide against negligence, fraud, and all those things by the what's it called? By the investment manager. So the investment manager will not say that because it will not lose it will not lose any capital if then it's because of that it goes to engage in fraudulent activities or negligent activities. So if it is found that the fund manager or the investment manager or the business manager is negligent in operating the business, or is fraudulent, or did not disclose a material fact, or is misrepresents or breach any of the covenants in the agreement, then there is a basis to ask that investment manager or business manager to make whole the investor. But the general principle is that the investor contributes the capital, while the business manager contributes their expertise, and profit sharing ratio can be agreed on any ratio among them. And if there is a loss, the capital provider bears the sole responsibility for that loss in the absence of fraud, negligence, misrepresentation, breach of covenant by the investment manager. So so we have what they call restricted mudoraba or unrestricted mudoraba. So in a restricted mudoraba is a sort of an agency where you've dictated what the investment manager should invest in. So it is restricted. Say, for example, when you have a stockbroker and say, please buy XYZ stocks for me. So if the stockbroker goes to buy a different stocks, the stockbroker will be acting on his or her own, or so that kind of restricted mudoraba. While unrestricted mudoraba is a situation whereby you just have your provide capital to the fund manager and say, oh, I'm investing 100 million naira with you, invest it in whatever stocks that is Sharia compliant and give me a return. So that is unrestricted. And that gives the fund manager or investment manager liberty to invest in different areas of its expertise. So this is a typical structure of how it works. The non-interest financial institution and clients enter into mudoraba agreement and fixed profit sharing ratio. So 50-50, 60-40, whatever ratio they want. So the client manages the business, or in the case of banks of a fund manager accepting investment. The fund manager manages the business. Profit sharing is shared according to the profit sharing ratio, while loss is absorbed by the non-interest financial institution. In this case, it is the capital provider. So whoever is the capital provider will bear the loss in the absence of negligence and all those things that we mentioned. So the essential elements, so the Mudorib is the investment manager, so the Rabbul Mal is the capital provider. The capital is what has been provided. So it has to be in money and it cannot be in debt, So as we mentioned in Musharaka as well, here it cannot be in debt. So the business has to be lawful. So the profit sharing will be agreed, and again, the language of the contract has to be very clear. So in applying it in real transactions, so on the asset side, the banks they use Mudaraba Musharaka principle for long-term financing, for project financing, to small and medium enterprise sector financing, letter of credit financing, working capital financing, and all that. They use it to create assets, meaning creation of asset, meaning lending out to customers. While in liability financing, is so in terms of attracting investors, that means taking deposits. So liability side, creating liability on their own book, meaning taking deposits on their own book. So current or savings accounts, interbank lending, securitization of large projects, mutual funds, so it is used by investment manager to raise deposit or investment from customers, and also term deposit as well. So that's how it operates in real terms. So lease arrangement. So we've talked about the equity-based kind of financing, and there are two types, Musharaka and Mudaraba. Let us not forget. Then in the lease, then we'll now talk about the debt aspect of it. And we'll be talking majorly about Ijara and Murabaha. So very quickly, under Ijara, we should be familiar with Ijara. It's just a lease, your finance lease that you see offered by even conventional banks. So it's quite similar to to the operation by an Islamic bank as well. So this is a simple leasing contract where a party leases an asset for a specified rent and term. So the key difference that you will see is that it is not every aspect that is not every asset that can be leased by an Islamic financial institution or non-interest financial institution. So non-interest financial institution will not lease cars to a brewery, for example, or a gambling institution. So and all that. So, but other than that, in most areas they are similar in the sense that if you wanted to lease an asset and you approach a Islamic financial institution, they buy the assets on your behalf and lease it to you for the duration of the financing. So if you wanted a 5 years lease, for example, they will lease it to you for 5 years, and you will be the payments that you will be making will be amortizing over the period of the 5 years until at the end of the 5 years, the asset becomes yours. So again, there are also different types of the leasing. So some of them are done as like an amortizing lease, or lease throughout the period. Then you just pay a nominal amount as maturity to own the assets. So but I mean the most sort of what has become acceptable more is like amortizing, which operates like finance lease. So as you are paying each of the rental, you are gradually becoming part owner of the asset, such that the last payment that you make, you will become the owner of the asset. So this is how an Ijara works typically the non-interest financial institution and the client agree on the terms of the lease. The financial institution purchases the assets, it leases it to the customer on a fixed monthly rental. The client purchases the asset from the financial institution at the end of the lease period. So either that or it is amortized in the cost of the lease. So the key element that you find is that, so the assets, it must be assets that is acceptable, it must be permissible, and it must be delivered to the lessee, so the lessor must own the assets, because you cannot lease what you don't have. Nemo that what don't have it. You can't give what you don't have. So you can't lease what you do not own. So we must ensure in the course of the transaction that the asset is owned by the bank or whoever is renting the asset to the other party. So the lessee is liable to compensate the lessor for every harm to the leased asset. So if you do not maintain the asset very well, you are liable to compensate the lessor. So rental must be known in currency and actual amount. So again, whatever rental has to be known. And let's also note that the rental can fluctuate. So it can be X amount today, it can be 10 naira today, and tomorrow it can be 11 naira. But more often than not, financial institutions try to maintain consistent rental across the tenure of the transaction. But note that the rental can be variable. So again, the contracts should be clear. There should be offer and acceptance. There should be consideration, and all the things that makes a valid contract should also be present. So think of Ijara as your normal finance lease, So you will be good. So the key difference is that in the conventional lease, the underlying asset can be anything. So I've mentioned that it is only permissible assets that can be used or financed under on an Islamic lease. So here as well, lease rental payment may commence prior to the acquisition of the asset because direct cash is given to the client, So under the Islamic finance Ijara, lease rental payment strictly commences only upon delivery of the asset to the client. Another difference is that the direct purchase of the asset by the lease is not necessarily supported by an agency agreement. So while under Islamic finance contract, if the client or if the customer will purchase the asset, it will be as an agent of the financial institution. So lastly, the lessor does not usually take delivery of the asset. They might not even see the asset. On the Islamic financial institution, they have to take the delivery, whether actual or constructive delivery of the asset. They have to take delivery of it one way or the other. So the other aspect of the contract, the second debt kind of contract, we've talked about the lease, is now the deferred delivery contract. So the istisna is a construction contract. So this refers to a contract of exchange with deferred delivery. It applies to specified assets that are manufactured to order. So here, at the time of signing the contract, the asset does not exist, So the Islamic financial institution now pays for the construction of that asset and sell it to the customer. So let's say, for example, I want to manufacture an airplane, for example. So, and I know the cost of the airplane to be 1 billion naira, for example. And if a financial institution wants to be able to earn a return of 10% on the 1 billion naira, so which should be 1 billion, 100 million, 1.1 billion. Let's put it that way. So the financial institution pays the manufacturer to construct the airplane, and now sells that airplane to the customer at 1.1 billion. It pays the manufacturer 1 billion and sells it to to the customer at 1.1 billion. So you see that the airplane is not existing now. It will be delivered in the future, but the price of has been paid upfront. So that is what is a seasonal contract is used for. It's also used for building. For example, if you want to build residential apartments or whatever apartments that you want to build, you can use a seasonal contract for the construction of that asset, and which will be delivered in the future, but you have fixed your markup today, because you sell it to the customer. The financial institution pays the manufacturer, and the manufacturer delivers it to the customer. Yeah. So yeah. So what's related to this is also parallel istisna, in the sense that as you are signing the contract with the manufacturer, you are signing a parallel contract with the customer, because the bank, for example, does not require the airplane, when it signs an istisna, a manufacturing contract with the manufacturer. So that is the first istisna contract. Then the parallel istisna contract is the contract with the customer, which is effective to sell the asset that is being manufactured to the customer. So that both of them run parallel, and the financial institution can mitigate its risk in that regard. So this is the basic structure. So the client approaches the non-interest financial institution for the construction of an asset. The non-interest financial institution enters into an istisna contract with the client. The non-interest enters into a parallel istisna contract with the builder to construct the asset and pays the builder. Upon the completion or at an agreed milestone, client pays the non-interest financial institution with respect to the portion due, the profit and margin, and client takes delivery, like we explained earlier. So the key elements, so it doesn't have to exist. So usually it is for asset that needs to be constructed in the future. So the quality and quantity should be identified. It can be amended over a period of the transaction, but it should be identified. So the terms of construction should also be agreed, and delivery the buyer, which is the customer, must take physical delivery, or whether direct or constructive delivery of the project. So the price may be paid in installments. The price should be fixed and can be paid in installments, and there should be other incidences of contracts. So offer and acceptance, there should be clarity of contract, consideration, and all that. Yeah. So let me run quickly to salam contracts, which is also a type of debt-based contract. So salam contract is usually used in agriculture, for farmers that do not have capital to plant their products and what have you. So they can approach a financial institution, and financial institution can provide them capital for the planting of their products, and buy those products from those farmers, and there will be a parallel salam, just like istisna. There will be a parallel salam to sell the farm produce to those farmers. So the financial institution will provide the capital for the farmers to plant, and to deliver specific number of goods or produce at a specific price. And there will now be a parallel salam between the financial institution and the farmers for the financial institution to sell those products to the farmers or to third parties, and this selling the product back to the farmers is only specific, is only allowed for salam contracts, not other type of contracts or assets that are being manufactured or that are existing at the time. So this salam contract is only specific to agricultural products. So I won't spend much time on this. I want us to quickly go through the Murabba contract, which we will see more often than any other contracts. So the Murabba contract is a purchase and sale contract in which a tangible asset is purchased by an investor at the request of a buyer from a supplier with a predetermined resale price. So, and I mentioned earlier that most financial institutions, most of their contracts are based on Murabba contracts. So Murabba means it's a cost plus contract. So let's say I want to buy a laptop, or a car, and the car costs 10 million naira, So I approach an Islamic financial institution to say, dear Islamic financial institution, I want to buy Lexus G or 6 GX60 or whatever, and the cost is 10 million naira. I get a pro forma invoice from Elizade or wherever for that particular Lexus. And what does the Islamic financial institution do? It gives me a form to say, an application form where I will say, dear Islamic financial institution, I apply to buy this XYZ from, I want you to buy XYZ car for me, and I promise that I will buy it from you after you have bought it for me, So on the basis of that promise to buy it back from the Islamic financial institution, the Islamic financial institution goes to Elizade, buys the assets, and now sell it back to you at a markup. So 10 million plus whatever profit it wants to achieve, whether it's 10%, 20%, whatever the environment speaks about at a particular time. So it's buys it on behalf of the customer and sells it to the customer at a markup. So note that the sale document where the financial institution will sell it to the customer has to be different from the financing document. So there will be a Murabba agreement where the financial institution agree that it will provide financing to the customer, on the basis of all those promises and all that. So after they sign that agreement, when the financial institution procures the asset, then it will enter into a different document which sells the assets to the customer, and the price of the cost price and the selling price, both of them have to be clear from the sale document. So you will know what the profit that the financial institution is earning. And one thing we should note is that the profits, because it's a sale, this price is fixed and there can be no change in the price. So what the financial institution does is that it sells it to you and you pay over a period of time, maybe 2 years, 3 years, whatever time is agreed with the financial institution. So and that price is fixed and cannot change irrespective of whatever happens. And when there is a default by the customer, the financial institution cannot get compensation for that default by the customer. What is usually done to prevent or to discourage default by customer is to impose a penalty charge. And that penalty charge cannot be consumed by the financial institution. It has to be donated to charity. Unlike a conventional institution, where if there is a default, it can be there can be a interest default charge, and it will be consumed by that conventional institution. So this is how it works in practice. The client approaches the non-interest financial institution to express an intent to engage in a murabba transaction facilitated by the financier. Subject to the financier's approval, the client signs a promise to buy. So this is very important because that promise to buy is an enforceable contract, such that if the client refuses to buy the asset from the bank after it has bought the asset, the bank can sue for specific performance such that you have to buy the asset, you know. So the non-interest financial institution purchases the asset, the non-interest financial institution sells to the client at markup, and the price, and the client pays in full or in an installment as pre-agreed between them. I will finish in 5 minutes. So again, the goods has to be compliant. It can't be any kind of goods, you know. So it must be Sharia compliant. The quantity must be agreed upon. So it is not permissible for it to be resold prior to delivery. So the goods must be delivered before it can be sold to the customer by the bank, you know. So the bank must take either an actual or constructive delivery of the goods. So the purchase of the goods, clients should not have made purchase of the goods prior to the Murabba agreement. So if you have purchased the goods already and you're just looking for a refinancing, the Murabba is not suitable for you. So the financier can appoint the client as an agent to go and buy the goods. So particularly for goods that has to be imported and all that, the financial institution can appoint the client as his agent to buy the goods. So supplier of goods must be a third party. So the client cannot be the supplier in a Murabba transaction. So clients can appoint an agent to receive the goods, you know. The price must be clearly stated and agreed upon. No portion of this is to be paid prior to the buyer taking delivery. So repayment, amount of each installment must be clear. The timing of each payment must be clear. Total duration of installments or number of installments must also be clear, you know. So you can take security, you know, and you can pledge the goods itself, you know. If it's a kind of good that can be pledged as security, you can pledge the goods that is financed as security. And we also mentioned about charging of penalty already. So the last bit is the supporting contract, you know. So we have the mortgage, the guarantee, the agency, the safe custody, Qard Hassan benevolent loan, uh, transfer of debts, donations, rebates, gifts, endowments, and all that. These are also contracts that are possible under Islamic finance, but we do not have time to go into any details at this time. So what other principles I think which we've highlighted earlier that we should also note is we should be clear. There should be no speculation, no ambiguity in our contract. It should be clear, you know. So gambling is not prohibited. So you cannot either finance gambling or engage in gambling yourself as Islamic financial institution. So in terms of combination of contracts, it is permissible to join two separate contracts into one, you know. So for example, when I was explaining I believe the Musharaka contract in terms of having the financial institution and the customer contributing capital to buy the asset, I mentioned Ijara as well, which is where the customer leases the asset from the financial institution, the financial institution ownership portion of the asset. So you can have combination of contracts, a lease and partnership contract can be combined, for example. Again, full disclosure of all material facts. So that's it from me at this time. I do not want to take too much of the time that have been allocated. There is a whole lot of aspects to Islamic finance, but this is just an introductory part, as I mentioned. I hope I've been able to give you an overview, and thanks a lot for listening.
Thanks a lot, Masood. Before I come back to say thank you, may I invite Toby Adebawale to coordinate question time. Toby, are you there?
Yes, I'm here, but I'm unable to see the questions. Not a host. Perhaps maybe Liz. Maybe I could probably take them.
Maybe are you able to see the questions? It's just one question.
I'm
Are you?
looking.
Okay, don't worry, I'll take it. Maybe I'll take it, right?
Can you hear me?
I can hear you. I'll just take the question straight away. So, Masood, there's only one question here, and it is, are Islamic contract principles very different from common law contract principles? And anyone who have any questions can throw them into the Q&A box whilst Masood is still with us. Masood, can you hear me?
Yeah, yes, I can hear you. Sorry, I didn't get the question. Could you take that again?
Okay, the question is, are Islamic contract principles very different from common law contract principles?
Okay. Well, I won't say they obviously they are not the same, but some of the you will find some principles that are sort of interrelated with one another. So they are not opposed to one another, so to say. So for example, the common law principles of offer, acceptance, consideration in terms of formulation or formation of a contract, you will find that in Islamic finance as well, but you just find additional principles to say you cannot invest in certain sectors. Common law may be indifferent to that. So say, yeah, once the business is permissible by the law of the land, you can invest or finance it. But Islamic finance will say, yes, you can invest in some of these areas, but there are areas that you cannot invest in. So that's how it operates. I won't say they are opposed to one another. They sort of interrelate. Some of common law concepts are embedded in Islamic financial concept as well.
Okay. So somebody else is asking, what is a Wakala agreement?
Okay, so Wakala agreement is just an agency agreement. All the common law of agency also applies. Wakala just means an agency agreement. You appoint someone to do something on your behalf.
Okay, thank you. And then an anonymous attendee is asking, who bears liability, especially where the investment does not meet Sharia principles, or a situation where the transaction turns out to be against Sharia? Is it the Sharia advisor or the originator issuer?
Okay, interesting question. So, if what you find in Islamic finance sector is that sometimes there can be difference of opinion between Sharia boards. So one Sharia board can say this investment is compliant, another Sharia board can say it is not compliant. So what you should do is, if you are always take guidance from your own Sharia board. So if your Sharia board said an investment is compliant, by all means invest in it, and if they say it is not compliant, please avoid investing in it, because if you invest in it contrary to the advice of the Sharia board, that can be considered as a negligent act, in which the investors can sue you. So if you're an asset manager, for example, and you invest in the funds of customer in a Sharia non-compliant instrument, then you can be liable as being negligent. Particularly if your Sharia board said that you should not invest in that kind of instrument. But if you are an individual, for example, and you take it that the instrument is compliant, yeah, it is your risk, you bear the risk and what have you. So there is no general body, so to say, that will say an instrument is non-compliant. It's more or less depend on the Sharia board that you are guided by. In Nigeria, just to add that in Nigeria, we have the Financial Regulatory Advisory Council of Experts, which is a body that sits with the CBN. They are responsible for certifying products offered by banks. After their Sharia board are certified, they also certify that the investment is compliant or the product is compliant. So if I guess that acts as sort of a safeguard. So if a financial institution now invests in a product that has been declared non-compliant by that phrase, I believe that financial institution will be negligent and will bear that liability.
Thank you very much. Another question is how is the profit different from interest? Please clarify again.
Okay, so in terms of profit and interest, under Islamic financial contracts, the return is linked to the performance of the underlying assets. So in a musharaka or mudaraba contract, for example, you do not just get a fixed return. The return that you're going to earn is dependent on the underlying assets. That's one. While in a debt-based contract, because it is not money that is lent to you, it's an asset that has been sold to you. So, for example, in a murabaha, I gave example of buying laptop and what have you. If I bought laptop for at 100,000 naira and I sold it to you at 110,000 naira, you are liable to pay me 110,000 naira. You cannot say I lend you money. I did not lend you money. I sold a laptop to you. So it is that asset, the presence of that asset, that differentiates it, that makes the difference. So in a lease-based contract, if I've leased an asset to you at a rental of a specific amount, you are bound to pay me that rent. Let's say just think about it, your landlord, tenant and landlord, the landlord has rented his apartment to you, irrespective of whatever happens, you will pay your rent, right, when they are due. And you cannot say it is money that has been given to you by your landlord. No, he rented a property to you. And that's how Islamic financial institution works. They intermediate with assets, not just money.
Okay, I'll ask you one. So we're running out of time, but let me just ask this quickly. Question in the chat box. Someone is asking, may I ask if you have to be a Muslim before you can apply or benefit from Islamic products?
Simple answer is capital no, 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 no. So you can be anybody. What's most important is what you want to do with the money. So if you want to invest the money in a non-compliance manner, then you will not be financed. But irrespective of whatever your creed is, you are very free to approach any Islamic financial institution.
Okay, let's take this one done very quickly because we have about 2 minutes to go. So please, what are remedies for default in Islamic finance, and can there be security interest in the property under the transaction?
Absolutely. So the remedy that you find is similar remedy as you find in your conventional transaction. So based on the nature of the contract, you can take security or over the asset itself, or additional security or guarantee, indemnity, mortgage, lien, whatever. You can take your normal security that you take in a conventional transaction for an Islamic transaction as well.
Well, thank you very much, Masood. Very illuminating, very thoroughly prepared paper. Thank you very much for the slides. I can see they're very comprehensive, and there were elements you didn't deal with, but I'm sure they were very useful to participants. And thank you for the way you've taken the questions. Your presentation style was is admirable. And thank you for taking out the time and having the patience and bearing with us throughout the process. We are extremely grateful. Interestingly, we've had about 4,900 people registered for this training, and more than 3,000 have participated so far. So thank you, and we're grateful to you and to every other panelist who's had sessions during the training. Thank you very much. Yeah.
Thank you very much for having me. Thank you.
And I'm sure we'll invite you again, and perhaps on another topic, and that you will indulge us when we do. Yeah?
I'm always at your disposal. Thank you.
Thank you, Basil. Thank you. Okay, so now we'll be heading towards the next presentation. Just to say that people have been requesting for the slides and all whatnot. I don't know whether they've received previous slides, but be rest assured that all the slides will be sent to all participants. And also at the end of the sessions, the recordings will be uploaded on the YouTube, NBA YouTube account. So it's now exactly 3:30, and we'll be moving to the second presentation. And that presentation will be on debt and equity capital markets. And the tutor for today is Aziza Musa Sadiq. Aziza is a partner of Banwo and Igodalo BNI, a leading law firm with offices in Lagos and Abuja. She obtained her law degree from the University of Lagos and joined BNI in 2006. She has a diploma postgraduate EU competition law from King's College London, Dixon Poon School of Law. She's a member of the Chartered Institute of Securities and Investment UK. In 2010, she was named as team leader in the firm's corporate securities and finance practice, with responsibility for managing many of the firm's most complex and pioneering transactions. She was admitted to the firm's partnership in January 2017. Her core practice areas are capital markets, mergers and acquisitions, and corporate restructurings, Islamic finance, taxation, consumer protection law, and competition law, having garnered over 15 years of experience working in these fields. Aziza is frequently called upon to participate in the rules development initiatives of the Securities and Exchange Commission of Nigeria and the Nigerian Stock Exchange, among others, and actively engaged in rules drafting, policy reform, and development in the Nigerian capital markets and mergers and acquisition space. Aziza authors articles in leading legal publications and delivers presentations on subjects in her core practice areas. She's frequently called upon to share her knowledge and experience as a participant, facilitator, and speaker at professional workshops, training, and conferences. It is my pleasure this afternoon to welcome Aziza, and I'm sure we will all enjoy the training today. Aziza, I yield the floor to you. Thank you.
Good afternoon, everyone. I'll just quickly share my slides. Can you hear me?
Yes, we can hear you loud and clear. Thank you.
I'll share my screen now. Okay. So this afternoon, we'll be looking at introduction to the debt and equity capital markets. And I'll try to be as detailed as possible within the time that I have. So what is capital markets? Capital markets I describe here as structures for transferring long-term savings in the economy to companies and governments for corporate, industrial, and infrastructure development. This shows that the participants in the capital markets are not limited to companies, and you can have governments and government agencies also participate in the market. Simply put, end users obtain funds from investors to meet their needs, the end users' needs, corporate goals, whilst investors yield returns in an ideal world. Capital markets include equity, which we refer to shares, debts like bonds, and then hybrid instruments like derivatives. Now, before I go into this, I'd like to distinguish between capital markets and money markets. So money markets are short-term markets where it's the same concept in the sense that you find debts being traded, but the debts are usually short-term, and we will see that as we go into the subsequent slides. So like I said, capital markets is broadly divided into equity and debt markets. You have the plain vanilla. Plain vanilla instruments are instruments that have general standard terms. They are not complicated. So we generally refer to them as plain vanilla instruments. We also have, as the market is developing, you have things like real estate investments, trust schemes, structured notes. You have the global depository receipts like the GDRs and Eurobonds. But for the purposes of this training, which is meant to just deal with introduction, we'll be focusing on the domestic market. It's segmented into two, the primary markets and the secondary markets. The primary markets is the markets where the new securities are sold to investing public by corporate issuers. So the first time companies issue securities or a state government issues bonds, it's the primary market. Whilst the secondary market is the market after the primary issuance, if the securities are traded on an exchange, the trade on that exchange between the original holders and potential new owners is that trade happens on the secondary market. So primary market again is divided into two. The primary market, capital market has two markets. The primary market, which is where new securities are sold and issued to investors, and secondary market where already issued instruments are sold or traded. Here I try to go into some of the terms that you'll see in the capital market space. You'll find something like initial public offer, which refers to where the company offers newly created shares to the general public for the first time ever. So the first time a company issues new securities, it's referred to as the initial public offer. You have the offer for subscription, which is the subsequent capital raise. And then you have the offer for sale. Now, I'll try to practicalize and give examples of transactions where all of these three terms have been used. In an offer for sale transaction, existing shareholders will sell their shares to the general public. In that transaction, the money doesn't come to the company. The money, the proceeds from the sale will go to the shareholders. I'm sure we've all heard or read about the MTN transaction. So the MTN transaction is an example of an offer for sale where the existing majority shareholder of MTN is selling shares to the public. So that is an offer for sale. The proceeds will go to the shareholders. Now, if MTN Nigeria decides to issue shares, its own shares to the public via a public offering, then that will be, if it was going to the public via a public offering, it would be an initial public offer where the company is the one issuing the shares directly and the proceeds from the sale will go to the company. Then you have the offer for subscription. Unfortunately, the equity market has been very, very quiet. So we've not seen all of these terms in recent times. But in offer for subscription, after I have done my initial public offer, any subsequent sale that I do to the public will be referred to as an offer for subscription. You are inviting people to subscribe for your shares. You also have the clearing system, and also another term that you see in capital market transactions. These are large, complex computer systems that enable securities to be traded without people handing over paper cash for paper certificates. So the clearing systems are like the back office. You know, as lawyers, when you want to transfer shares, we'll fill share transfer form, you give it to the company secretary. For private companies, the person will update the register, it's manual. You need to hand over something and it's all done on paper. With the clearing system, where the trade occurs on the exchange, they have computer systems that are linked to those trading platforms such that they can be backed up and settlement of the shares. That's the person buying will receive their shares. The person selling will get money for what they are selling. We have examples of the clearing system. We have the Central Securities Clearing System, PLC, which we generally refer to as the CSCS. And then you also have the FMDQ Clears Limited. Then you have book entry. If you hear people talk about book entry, it's the computerized ledger systems where entries are made into to update the register and to update holdings by the new buyer and the old seller. Then you have the rights issue. Rights issue is offer of new shares to only existing shareholders. So in a rights issue, the members of the public are the ones that the shares are offered to. Although for publicly listed companies, the law allows you to trade your rights. So if I'm a shareholder of a company and the company is doing a rights issue, in the rights issue process, there is a provisional allotment of shares to me based on my existing shareholding. So that provisional allotment, if the company is listed on the Nigerian Exchange Limited, I can actually trade the rights such that the person buying my rights will now buy the shares that have been provisionally allotted to me. Now, before, when rights issues were still rights issues, they are usually done at a discount to the market. So if, for example, the company's shares are trading at 30 Naira, a company can decide to do a rights issue for 28 Naira. And because the rights can be traded, I, as a shareholder, can go to the exchange through my stockbroker and trade my rights. When I trade my rights, I'll probably sell for the 30 Naira. I make 2 Naira profit. 28 Naira goes to the company because that's the price at which they have offered the rights issue. The shares under the rights issue will go to that new investor that I sold my rights to. So when you hear trading of rights, that's just a summary of how it happens. I have a right to provisionally allotted shares under the rights issue based on my shareholding. I am not interested in taking up those rights, but I want to make money out of the rights issue, and the law allows me to do that. And it is not to the detriment of the company. I go to the exchange through my stockbroker. I trade those rights. I remit the money that belongs to the company, and then I take the difference, if any. I mean, because of the way the equity market has crashed, rights issues have been far and in between. And in some cases, the companies will do them at the market price. So there's really no incentive to trade the rights. But where the rights is done at a discount to market price, then shareholders have the opportunity where the shares are listed to trade those rights. You also have what we refer to as tender. Tender is an offer of specific quantity of shares by way of bid process. Now, tender is not something that is common under Nigerian law for capital raise, but you will see things like tender offer, where I am saying that I want to buy shares of a company and I'm inviting the shareholders to tender their shares for me to purchase. Then you have the next term we looked at is listing, which is where the securities are officially admitted on a stock exchange for trading. Then you have listing by introduction. Listing by introduction is, remember when we talked about initial public offer, I said the company will raise capital for the first time. We talked about offer for subscription and we talked about offer for sale. In a listing by introduction, there is no sale by anybody. The company applies to the exchange to say that I have these listed issued shares and I would like to list them on the exchange. There is no capital raise involved in a listing by introduction. And an example of a listing by introduction, again, I'll use MTN. When MTN listed on the floor of the Nigerian exchange, what it did the first time was a listing by introduction. So MTN took all of its issued shares and listed them on the floor of the exchange, providing an avenue for its shareholders to sell them in the secondary market. Recall that we discussed primary markets and secondary markets. So in a listing by introduction, there is no capital raise. nobody makes money, unlike an initial public offer where I said the company makes money. In an offer for subscription, the company makes money. In an offer for sale, the shareholders who are selling their shares make money. In a listing by introduction, at the time of the listing, there is no capital raise. However, after I have listed those shares, I can decide to trade them, and the exchange will require that we make some shares available for those who are interested in buying. But there is no dedicated or deliberate attempt to raise capital by anybody. It's an opportunity to trade in the shares. We have the over-the-counter OTC market, which is trading of securities via a broker-dealer network, as opposed to a centralized exchange. So the Nigerian Exchange Limited, for example, is a centralized exchange where there are systems and things are monitored and there's a physical location. For OTC markets, you do not need to have physical locations. Rather, the trading will occur electronically. So the person buying and the person that wants to sell will connect to each other electronically, and the trades happen electronically. You also have a term that you probably have seen in documents: qualified institutional investor or high net worth investors. They are a selected group of savvy investors defined in the SEC rule. Now, I have deliberately not set out the definition here because the definition changes. I mean, the last change I think was done in December 2019. But for qualified institutional investors, you'll find like investment like banks. They are mostly qualified institutional investors, and then high net worth investors are defined based on their assets. I mean, so from the term high net worth is based on what you own, and the threshold to qualify as high net worth investor or an HNI, as we commonly say, is defined in the SEC rule. Now, another term that as a capital market lawyer you need to be familiar with is fixed price offering. Now, I'm going to try to take fixed price offering together with book building because they are both pricing mechanisms. They are both methods at which shares are sold or securities are sold in the capital market. The prices of securities are sold or securities are sold in capital markets. In a fixed price offering, a company decides to raise capital, say an offer for subscription. The company working with its advisors will determine the price at which they want to sell the security to investors. So I'll work with my advisor. I can decide that the worth of my security is 20 naira, 50 naira. I go to the regulator, get regulatory approval. The regulator does not regulate the price. The regulator approves the offer documents, and then I go to the public. If the investors or the investing public believe that the worth of my company is actually that 20 naira, they will participate. And for a long time, up until 2011, that was the only means of offering securities in Nigeria. Everything was done through fixed price offering. Now, if you are unlucky and the public believes or is of the view that the price at which you are offering your security does not reflect the value of the company, then you run into the risk of the offer failing because people will not take up the securities. Now, as the market developed, the book building was introduced into the Nigerian market. Book building is a price discovery method of determining the price of securities. And it's done by, so the issuer together with its advisors will, looking at market conditions and the valuation they believe reflects the value of the company, they will put a range and say, look, we think that this security should sell between 20 naira and 30 naira, between 20 naira and 25 naira. They will issue a prospectus called the Red Herring Prospectus. And we call it Red Herring because it has everything about the issuer other than the price. I issue this document and I would distribute to my qualified institutional investors and high net worth investors. And based on their own review or feedback, they come up with a range. And when they come up with that range, the issuer together with his advisors will determine the average, and that will be the price. So between 20 naira and 25 naira will be my range. If the average at the end of the day is 22 naira 50 kobo, I would have seen that the market believes that 22 naira 50 kobo is actually my worth based on the risk they are willing to take, and not 25 naira. So a book building allows or assures more of success than a fixed price offering, because the final price will be based on the interest and the price discovery process, which we refer to as book building. So a book is opened, an order book is opened, where investors will say, I'm willing to take 10 securities at 20 naira. I can take 15 securities at 22 naira 50 kobo, 30 securities at 20 naira. And based on that, you can see the demand and the appetite, and I come up with the price. And eventually, that will also make me finally determine my offer size. So if, for example, I was going to raise 200 million naira, and based on the price, the book building, I see that people are only, the aggregate interest is only for about 150 million. Then in my final document, my offer size will be 150 million. If you compare it to a fixed price offering, if I had done it at 25 naira, I won't have the opportunity to get the feedback because it's fixed price offering. Investors will just not take up my security, and then the offer may fail, unless, of course, I have underwritten it where there is an underwriter, which we will go into in subsequent slides, that may cushion the effect of investors not taking up the security. So book building is a term that you see a lot. It's used for both equity and debt instruments. For debt instruments, it is used to determine the coupon rates based on demand and what the market is saying. So the book runner is the person that runs the order book during book building and determines allocation of securities based on the order book. In practical terms, the financial advisors are also the ones that run the book. So sometimes in transaction, you will see them being described as issuing house / book runners if they have both roles. Then another term that you'll see in capital markets, particularly for debt instruments, is callable, which applies to bonds and other debt securities that may be redeemable by the issuer prior to maturity date under specific conditions. So typically, bond instruments or debt instruments are issued for a fixed period, say 10 years, although there are new instruments being developed that are perpetual bonds, but we are not going into that in this class. So I issue an instrument of 7 years, and I give an option that in year 5, I, the issuer, will want the opportunity to redeem earlier than 7 years. And the reason why you find this in transaction documents sometimes is that if I raise capital today and based on market condition, the interest rate is, say, 10%, and in the next 5 years, interest rate drops to 3.5% or 4% or whatever it is, I will not want to continue paying that my 7% because market condition has changed. I would typically calculate the price or the cost of paying that 7% for the remaining 2 years vis-a-vis redeeming it in year 5 and paying whatever premium, if any, that I have agreed with the bondholders to pay. So when you hear instruments, when you see transaction documents and they say that the bonds are callable, it means that the issuer can call or redeem the bonds prior to the maturity date, subject to complying with the specific conditions that would have been set out when the bonds were originally issued. If the bonds did not have callable feature at issuance, you can advise, if it's really important for the issuer to redeem those bonds, that the terms and conditions be amended in accordance with the trust deed to allow for this. Another term you'll see in capital markets is over-allotment, sometimes referred to as over-allotment, sometimes referred to as price stabilization, and also referred to as green shoe. It is an option granted by an issuer in favor of a stabilization manager to purchase up to a certain amount of eligible securities at offer price during the stabilization period. Now, I'll try to break it down. Typically, when you do transaction, if for example, I'm issuing my shares of XYZ Limited and I've issued it at, say, 30 Naira, and after the transaction, say I did an offer for subscription or an IPO, the market, people begin to dump their shares there are more people willing to sell than people willing to buy. Where you have more demand, where you have more supply than demand, the price will fall. Now, because I want to maintain my price and I don't want people distorting the price or just dumping the securities, I will get someone referred to as stabilization manager to buy those securities at the offer price, such that depending on what the situation is, I can either buy more from those people that are buying or issue more to meet up with the gap, if it's that there is more supply than demand or if there's more demand than supply. Now, it's something that is fairly recent in Nigeria. I mean, I'm not sure that it's actually been tested in any transaction, but the rules now provide for it and is referred to as Green Shoe because the first company to use it internationally is a company called Green Shoe Company. I'll advise that you study the exchange rules on stabilization to understand how it works practically. So that's a summary of the terms, some of the common terms that you see in the capital market space. We now go into the laws. Now, to be a capital market lawyer, capital market is rule-based and statute-based and sometimes can be overwhelming, particularly the way the rules are issued by the regulators and the frequency in which they are issued and the different amendments. One thing I always advise is that it's not possible for you to cram all the laws or cram all the sections, but to have a good grasp of capital markets, you need to understand the basics. Once you understand the basics and you know where to find the rules or the laws when you want to advise on a transaction, that's how you build capacity. Because the way the rules are, as we go into it, you will understand better. So the first rule and the principal legislation that governs capital markets is the Investment and Securities Act, number 29 of 2007. This is a law that, first of all, it was in Kama 1990, and then it was in 1999, we had the Investment and Securities Act of 1999, and then the investment, because it was yanked out of Kama and made a standalone. I think it used to be Chapter 17 in Kama. Then it was put as Investment and Securities Act 1999 before it was now reenacted in 2007 into what we have today, which is the Investment and Securities Act. It provides for registration of securities and regulation of capital markets operators. So that is the law that says that every public company must register their securities with the Securities and Exchange Commission before they issue it. That is the law that establishes the IST, that's a tribunal. That's the law that stipulates sanctions, some sanctions for breaches by capital markets operators. And that is the law that empowers the SEC to make rules and regulations that govern the capital markets. You also have the Companies and Allied Matters Act of 2020. I mean, so there are certain sections of CAMA that affect capital market transaction, particularly in terms of authorization, who can do what a public company can do and what a private company cannot do. As you see, Section 22 restricts private companies from inviting the public to subscribe for any share or debenture of the company or deposit money for fixed periods or payable at call, whether or not bearing interest. So this section of CAMA already shows that a private company that wants to raise capital amongst members of the public will need to be registered into a PLC. We also have an interesting section of CAMA, a very interesting one, in the sense that prior to 2020, preemptive rights on issued shares of public companies was regulated by their memorandum and articles of association. And for most public companies, the memorandum and articles of association will provide that before you issue, unless the shareholders determine otherwise at a general meeting, any new issuance of shares must be offered to the existing shareholders first. But it's always allowed that the company at general meeting can decide otherwise. Now, we have this section of CAMA, section 142, that provides that a company shall not in any event allot newly issued shares unless they are offered in the first instance to all existing shareholders of the class being issued in proportion as nearly as may be to their existing holdings. The section does not distinguish whether such provision will apply to private or public companies and reads as though it is a mandatory provision for all companies. So for a lot of companies now, when they do think of raising capital, either by way of private placement or they want to do an offer for subscription, they need to deal with section 142. And there are different schools of thought because section 142 seems to have vested shareholders with the right, with the preemptive right. And so it is a personal right attached to each shareholder. So the question comes, which is not a question for this session, can shareholders at a general meeting waive the preemptive right of everyone? Or do I need all the shareholders? If I have 300 shareholders or 1,000 shareholders, how do I get them to waive their individual rights? It's a section that we are really hoping will be amended. It's not clear how it got into CAMA because, like I said, before 2020, public companies had a process in their articles of association on when the preemptive right will be triggered and when it will not be triggered before the section 142 was introduced. You also have section 222 that deals with registration fee for securities, and then there are certain pre and post-transaction filings. And one other thing, I'm not sure if I included this in the slide, is that when you're advising on a bond transaction, you need to be mindful of the sections of CAMA that deal with debentures. So the provisions of the trust deed must comply with whatever you have in CAMA on content of a debenture trust deed, because definition of debenture in CAMA it also includes the bonds that we issue in capital market space. Then you have the SEC rules and regulations 2013. Now it's 2013 because the SEC codified in 2013. And since then, we've had several amendments, which is why I say that it's not possible to cram all the amendments. We had amendments in 2013, we had amendments in 2014, we had amendments in 2015. I mean, I can't say of 2016. In 2017, there were about 3 or 4 amendments. And then we had in 2019, we had in 2020, in 2021, we've had about 3 amendments. These amendments will amend another rule. So it's not possible to cram everything. So as a capital market lawyer, when you're advising on any transaction, you start with your 2013 rule to see the provisions of the rule as it relates to your transaction. Now, in order to be efficient and deliver diligently on your task, I will advise that you now take all the amendments from 2013, from 2014, May 2014, I think was the first amendment. You need to go through those amendments to ensure that what you have read in the 2013 codified rule has not been amended. Most times, we get tired or we forget. So every capital market lawyer, if you really are interested in capital markets, you need to ensure that you download the 2013 rules and then you go to SEC's website and download the amendments and save them. The final, not the exposure draft, the final rule. That's the only way you can be up to date with the rules. And please don't try to cram because it's almost impossible to cram, but you need to read the new rules as they come out just to have a gist or an overview of what the new rule is talking about. Because once you read it, then it's somewhere. You don't need to, you may not necessarily know all the exact text, but it's somewhere in your subconscious that looks like SEC issued this new rule. And when you are working on any transaction, please do remember to always go back to the various amendments post 2013. We are really hoping that SEC will go through another codification process after the 2013 one, given the magnitude of the rules that they've issued since that time. So the SEC rules was issued by SEC pursuant to the ISA, as I said earlier. It provides for registration of securities with SEC and sets out registration requirements. It specifies registration requirements for capital market operators and regulation of their activities. It sets out the process and requirements for obtaining the approval of the SEC. It also sets out what transaction documents must contain. So you cannot effectively review a prospectus or a right circular or any transaction document or draft a transaction document for a capital market transaction without going through the relevant rules as it relates to that transaction. The rules also set out sundry and detailed rules regarding raising of capital, duration of offer, cost of offer, the requirement for consent, treatment and use of proceeds of offer. It provides for things like underwriting. So all of this you would find in the SEC rule. Now here we have other laws that also, we use them in our day-to-day, depending on the structure of the transaction. You have the Trustee Investment Act, you have the FMDQ bond listing and quotation rules. As a capital market lawyer, you do need to be familiar with these rules in terms of, if I'm doing a transaction that involves a state government, then I need to read the external and domestic borrowing guidelines issued by the DMO, right? If I'm advising on a transaction that will be listed or quoted on FMDQ, then I need to know that I should check the FMDQ bond listing quotation rules. Not all the rules will apply in all transactions. The applicability of the rules will be dependent on the transaction structure. Now you have the Ngx Rule Book 2015. It stipulates the rules and disclosure requirements. It specifies rules for dealing members and then sets out key listing requirements. Again, similar to the SEC rule, the rule book was codified in 2015. I remember when I first started capital market transaction in 2006, we used to call it the Green Book. And it was always very difficult because it's one small green book with several amendments introduced by the exchange, but they codified in 2015. However, like SEC, they've also issued so many rules, so many amendments. So when you're advising on a transaction, you take the 2015 rule book, and then you need to go through the amendments, the various amendments that the exchange has issued. Hopefully, maybe another codification will happen very soon. So this is the capital market space that I tried to put in this diagram. So you have the SEC, you have the Ministry of Finance, you have the exchanges, you have issuers, you have the clearing system that I described earlier, you have custodians that maintain assets on behalf of investors, you have the market makers, you have investors that are participants, you have issuing houses, you have the trustees, you have the registrars, and then you have us, the lawyers. We all form the capital market space. So this is a snapshot of what the capital market space is about, the different participants and the enabling framework. For every capital market operator, we all rely, the powers of the SEC is the apex regulator in capital market space, and even the exchanges like the Nigerian Exchange Limited or the FMDQ all derive their license from the SEC. So the regulators, like I said, so a SEC is the apex capital markets regulator. It administers the ISA, and then the key functions include registration of securities and capital markets operator. They protect investors, and then they approve capital markets transactions based on the rules. The key transaction documents, which we'll go into, they monitor utilization of proceeds, and then they sanction erring capital markets operators. Then you have the Nigerian Exchange Group, which I'm sure we're all familiar with the demutualization that happened last year and how it's moved away from being a limited by guarantee to a company limited by shares, and you have the Nigerian Exchange Group PLC as the old co with all the subsidiaries. So you will not find the Nigerian Stock Exchange. What you'll find now, the exchange is now the Nigerian Exchange Limited. Then you have the Ngx Regulation Limited, which is the independent company that ensures enforcement and compliance with the rule book. And then you have the Ngx Real Estate Limited, which is the real estate company that is also within the Nigerian Exchange Group PLC. The exchange specifies listing requirements, ensures compliance with those rules. They regulate the secondary market activities. They also have there are 3 different boards on the Nigerian Exchange board. You have the main board. The main board is that board where the way the boards are is different companies meeting different criteria set out by the Nigerian Exchange will determine where you want to list. So you have the main board. The main board is the board that we all see, where you hear, well, think this is a capitalization. It's typically tied to the main board where most companies are listed. On the main board, there are 3 different standards. You have A, B, and C. Each standard has its listing requirements that you must fulfill in order to be listed on the main board. You have the premium board, which from the word you understand it's the premium. So for companies that meet certain requirements, particularly when it comes to corporate governance, they are admitted to the premium board. And you have companies like Dangote Cement, Zenith, and MTN on that board. And then you have the growth board. The growth board of the exchange is that board that they're trying to bring in smaller companies who the exchange believe, and the companies also believe that they may need some visibility that will allow them to raise capital. So the listing requirements on that, for the growth board, is not as stringent as you have it on the main board. And the listing requirements on the main board is not as stringent as what you have on the premium board. But the main board is the most common. And then you have the premium and the growth board as well. Then the FMDQ, also structured as a holding company with different subsidiaries like the FMDQ Securities Exchange Limited, the FMDQ Clear Limited, the FMDQ Depository Limited, FMDQ Private Markets Limited, and then the IQX Consult. Again, you just need to be familiar with that there are these regulators. They have their different rules that apply depending on the transaction that you're advising on, and the rules are easily accessible on their respective websites. Then you have the NASD. The NASD is also a self-regulatory securities exchange registered by the SEC. It provides a trading platform where securities are not listed on any traditional exchange. So you have the stock exchange or the Nigerian Exchange Limited, which is a traditional exchange where you find where people buy and sell. You have the NASD, which is like an OTC platform. Remember that when we're describing or discussing the terms used in capital markets, I talked about the OTC platform that is not a centralized exchange, but where people trade electronically. So before 2017, the NASD really existed, and people there are a number of public companies that are not listed on the Nigerian exchange whose shares trade on the NASD. However, in 2017, the SEC issued a rule that the shares of public companies can only be traded if you're a public company and you are not listed on the exchange, and a shareholder wants to sell its or his shares, those shares must be traded on an OTC platform such as NASD. So as a capital market lawyer, if a client comes to you that I want to sell my shares, and the client holds shares in a public company, and you check the list on the Nigerian Exchange Limited, you see that the company is not listed, and you tell them we just sign share transfer form. No, they cannot just sign share transfer form, because the SEC rules now require that the shares of a public company, a public unlisted company, must be transferred through an OTC platform such as the NASD. So the clients will need to go through the NESD process for transfer of shares. They have their own dedicated transfer form and the process in order to do the transaction. So again, please be mindful that the fact that the company is public and unlisted does not mean that they can sign or transfer shares the way a private company can transfer, the shareholders of a private company can transfer their shares. The rules require that those shares be transferred on a platform such as NESD. Then you have the IST, which is established pursuant to the ISA. It resolves disputes relating to capital markets activities between capital markets operators and regulator, capital markets operators and investors, quoted companies and regulators, and where two capital markets operators are having disputes where capital market operators are disputing amongst themselves. It resolves disputes on interpretation of capital market laws and regulations, and the judgments are enforceable. They have the same jurisdiction as the Federal High Court, and appeal lies to the Court of Appeal. Now, raising capital. Why would I want to raise debt and not equity? Bondholders do not have ownership interest. So these are the things, I just want to go through some of the things that clients will ask you or may ask you, okay, I want to raise capital. What do you think? Which one do you think is preferable from a legal perspective? Do I get any, are there any downsides from a legal perspective if I decide to raise equity or if I decide to raise debt? Now, bondholders do not have ownership interest because if you do a debt transaction, it doesn't dilute the existing ownership structure of the company. So the shareholders will continue to remain shareholders and their interest will not be diluted. Bondholders are only entitled to repayment of the agreed upon principal of the loan. So if I invest 20 Naira, I'm only entitled to my 20 Naira plus interest, if there is interest, unless it is a zero coupon bond. A zero coupon bond is a bond that does not, there's no interest payments on it. When I go into types of bond, I'll describe how it works. So bondholders do not have any direct claim on the future profits of the business. If the company is successful, so I borrow money to do a project. When I complete that project, my profits will increase significantly. I distribute my profits to the extent that I meet up the requirements of CAMA on distributable profits to my shareholders as dividends. But the person that I used their money to do the project is only entitled to what they gave me, plus the interest I assured them I would pay on the money. So that gives the client an overview. Now, another thing is that for debt transactions, the interest payment is a deductible expense subject to other conditions in the law. It's a deductible expense. So that 10 Naira that I pay as interest, I can deduct it before I pay my tax. I deduct it as an expense in my books in determining my taxable profits. So again, you tell the client that these are the benefits. Also, except where you have variable rates of loans, the interest and principal obligations are known because that interest payments, the interest amount would have been determined at the time where I issue. So if I'm going to pay you 5%, that 5% is known. If it's a fixed price offering, where the coupon rate is not attached. If it's floating rate or is attached to something, then I may have variable rates. But generally, interest obligations are known amounts, which can be forecasted and planned for, unlike dividends. Debt securities are instruments evidencing a debt under which the issuer promises to pay the holder the amount borrowed, usually with interest, on a specified future date. These instruments can take many forms. You have the debt instruments, so they're usually with tenor of 3 to 30 years, depending on the corporate and what the corporate entity seeks to achieve, or whether it's a sovereign. Bondholders are assured of their principal repayment and interest payments over the life of the bond, and borrowers can deduct interest on the borrowing as a tax deductible without the need to give ownership rights or profits to investors. So for zero coupon bonds, for example, the way it works is that, so for fixed rate bonds, I will know the rate of interest from day one. For floating rates, the rate is not known, and it will be based on the indices that I set out in my trust deed. For zero coupon bonds are those bonds, like I said, where there's no interest obligation. I'm sure you start thinking that, so what's the gain for the investor if there won't be any interest? When zero coupon bonds are issued, they are issued at a discount to the par value. We all know what nominal value is. So the nominal value for most companies for the shares is 50 kobo. For most bonds, the nominal value is 1,000 naira. It's not dictated by any law. It's just, for me, it's something that has evolved over time. So say the nominal value of the bond is 1,000 naira. For zero coupon bonds, I will sell at a discount to that 1,000 naira. So I'll issue it to investors at 900 naira. So I'm giving them an instrument worth 1,000 naira for 900 naira. At maturity, I will pay them 1,000 naira back. So their own gain is not a periodic coupon payment, but it is the gain that they get when the principal is repaid, because when the principal is repaid, I will get the full face value of the bond, even though when I bought it as a discount to the nominal value. Again, I bought for 900 naira, a bond that is worth 1,000 naira. At maturity, I will get 1,000 naira back from the issuer, and my gain is the difference between that 900 and 1,000, which is 100 naira, multiplied by the number of bonds that I bought. Now you have the FMDQ noting of private company bonds. And here I would like us to pay attention to the specific term being used. Remember that when we were talking about authorizations in CAMA, we read in CAMA that if you're a private company, you cannot raise capital, issue bonds to members of the public. So what FMDQ noting platform does is to allow private companies issue bonds via private placements and to note their securities. Remember, the word is noting, not listing. I mean, we've had issuing houses get into trouble with SEC where they were doing transactions that were noted on the FMDQ platform, but the transaction document had referred to list. It is not a listing because it is not available for trade to members of the public. What FMDQ does is to note that instrument, that look, this instrument is available. They provide information about the issuer to qualify the institutional investors. So if I read up about that issuer and I am interested in their security, whether it is bonds, whether it is shares, FMDQ has said it will also go to equity, but I don't know that there's any equity for now. They will now reach out through the dealers that are licensed by FMDQ to buy from someone that is interested in selling those securities. So it's not open to the public. And the terminology that is used in transaction documents where the securities will be noted on FMDQ private company platform is noting and not listing. The FMDQ has its rules. Remember that I said that every regulator, almost all regulators, have their specific rules that you will need to comply with in order to be eligible to list on their platform. So this is just a snapshot of what you have in the FMDQ rules. Again, you need, as lawyers, you need to be familiar. If you are working on a transaction that involves a private company that wants to note on the FMDQ, you need to read the bonds noting guidelines if they are bonds. I know they have one for Sukuk now as well. I'm not sure if they have for equity yet, but they do. They've said that they will also develop one for equity. So again, those are the rules you need to be familiar with, not the FMDQ bonds quotation rules. This is noting and it's applicable to private companies. Then you have the green bonds, another type of instrument in the debt markets. These are bonds used exclusively to fund projects that have environmental or climate benefits. I mean, so it's really that there are certain investors, particularly international investors, who will say that the money they have raised from their investors can only be invested in projects that have environmental or climate benefits. So those are the green bonds. And to qualify for a green project under the SEC rule, you must meet certain requirements. Again, if a client comes to you that they want to issue green bonds, in addition to reading the general rules that apply to bonds, you also need to review and ensure that the transaction document and the transaction structure complies with the SEC green bond requirements. The FMDQ has also launched a green exchange, and they also have their rules on what the requirements are for a company to be listed on the green exchange. Again, in advising on transactions that are green bonds, or you need to ensure compliance. If they will be listed on the FMDQ, or if they will be issued to members of the public, then you need to check the SEC rules. And then SEC also has rules on social bonds. To qualify as social bond, the proceeds of the bonds must be applied towards one or more specific, one of the following social projects. So they've given examples of the social projects in the SEC rules. And so again, if you're advising on a transaction that involves social bonds, you just need to ensure that it complies with the requirements of the rules. And we also have rules on asset-backed securities in the SEC rule. If you are working on a transaction that will involve an asset-backed security. So the SEC rule defines asset-backed security as certificate, whether written or in electronic character, issued by a special purpose vehicle, the repayment of which shall be derived from the cash flow of the pool of assets. So I will issue bonds or issue those securities and say that my source of repayment is from this pool of assets that I have attached to those securities that I'm issuing, and typically issued by a special purpose vehicle. So again, when you're advising on a transaction that looks like or is an asset-backed security, you need to ensure compliance with the SEC rules, both in terms of structuring and in terms of documentation and the content of the document. Then you have the high yield bonds. Again, I'm sure we hear it sometimes because in capital market, there are so many buzzwords. High yield bonds are also known as non-investment grade bonds. So they are bonds that are issued by companies that are either highly leveraged or are experiencing financial difficulties, or it's an emerging company. So they are not investment grade either because of the financial performance of the company over time, or the fact that the company has not been able to generate enough performance in terms of history, so they don't meet the rating requirements, and because there is higher risk of default accompanying such bonds, they usually pay higher rates of interest. Then you have the collective investment schemes. Again, in the capital market space, the CIS are pooled investments, proceeds of which are used to invest in assets such as bonds, equities, or other instruments allowable under applicable laws. You could have it as open-ended or closed-ended. And in the next slide, I think I talk about them. So the investment objective, when we go into equity, I go into detail on what collective investment schemes are and how they're structured. Now, equity. Why would I raise equity and not debt? Ultimately, equity is a cheaper source of fund. The ratio and quality of equity raised will largely impact ability to successfully raise debt capital. What this means is that for a number of cases, or in a number of cases, particularly where it's project finance, the banks will want to see what the quality of equity is, how much have the shareholders put in, and who are the shareholders. And it's better suited for investors with medium to long-term plans because there is more risk in equity transaction. Your ability to gain on return on investment is dependent on the company making sufficient profit. If the company does not make sufficient profits, distributable profits, then it will not be able to declare dividends. Now, if again you are unlucky and the shares are not trading, so you cannot exit because nobody wants to buy. So there is more risk in equity. So that's why it's more suited for investors with medium to long-term plans. So we've gone through initial public offering. We've talked about listing by introduction, and then you have listing of depository receipt. Because this is an introductory class, I did not go into detail on depository receipts because it's a whole class on its own. I'll just give a description of what depository receipts are. So depository receipts are issued by entities called depository, and they have underlying shares attached to them. So I'll use a live transaction. So GTB, for example, has global depository receipts. The depository bank issued that receipt, one receipt. Under each receipt has 50 shares underlying it. So if I hold one receipt, because those shares of the Nigerian bank, there are certain restrictions in a number of international exchanges with regards to listing and with regards to ability to trade those shares. So in order to allow international investors who for some reason cannot also come to Nigeria to invest, but it's easier for them to invest in a receipt that is listed on their exchange, a bank or a company would determine and work with a depository to say 50 shares, for example, equals one receipt. So if I hold one receipt, my underlying and my beneficial interest is in 50 shares. But what I hold is not, I don't have direct ownership of the 50 shares. The ownership of the 50 shares will be in the depository, who may hold directly or through a custodian. And the depository will give me the number of receipts. So if I put in 200 naira and one share is 20 naira, so my 20 naira, my 200 naira will give me 10 depository receipts. One depository receipt may equal 50 shares. So for every one receipt, I have interest, underlying interest in 50 shares. Like I said, depository receipt is a class on its own, so I didn't bother to go into it here, but we have framework for issuing depository receipts in the rule book of the Nigerian Exchange, as well as in the SEC rules and regulation. You also have the concept of dual listing. A company may choose to list on more than one exchange, with the Nigerian exchange serving as the primary exchange or secondary exchange. So you have a primary exchange where you would have listed first, and then you have a secondary exchange where you would like to list because you have shareholders or you have investors who are interested in your securities and their preference would be to be able to trade in that other exchange. Now, in terms of your primary listing, you'll be required to comply with the disclosure obligations of your primary listing first. And then once you do that, whatever you do on your secondary listing, you will notify, whatever you do on your primary listing, you will notify the regulator of your secondary listing. Then you also have the reverse acquisition or reverse merger, which again is not very common here. I've talked about the main board and the growth board. The alternative securities market and the growth board are available to small and mid-sized fast growth companies to raise critical long-term capital. Now, to collective investment schemes, I'll quickly run over collective investment schemes before we go into the stages involved in a capital market transaction. So CIS are pooled investment, proceeds of which are used to invest in assets. It's defined in the ISA as a scheme in whatever form, including an open-ended investment company, in pursuance of which members of the public are invited or permitted to invest money or other assets in a portfolio. So two or more investors contribute money, and that money is given to the fund manager. The fund manager will invest the money based on the investment policy of the fund. Now, so sometimes you will see funds called money market fund, bond fund, dollar fund. So if it's a money market fund, it means that the primary purpose of that fund is that I get money from investors and I invest it in money markets. For each of the different types of fund that you see, the SEC has rules on how the investments can be done and what the obligations on the respective fund managers in order to ensure that the investors' interests are adequately protected. So the types of collective investment scheme recognized in the ISC and the SEC rules include, you have the unit trust, you have the venture capital funds, open-ended investment companies, real estate investment companies or trusts, and then you have the specialized funds. Now, the open-ended investment company is defined in the ISA as a company with an authorized share capital whose article of association authorizes the acquisition of its own shares and is structured in a manner that it provides for issuing of different securities. So for an open-ended investment company, I would raise money from members of the public, but I'm allowed to buy back the shares that they hold, which are given to them as a result of their investments. The ISA provides that the provisions of CAMA on share buyback will not apply to an open-ended investment company. So where you see an open-ended investment company, or you are being asked about an open-ended investment company, please do not say that there will be challenges because they cannot do buyback under Nigerian law. The ISA provides that the provisions of CAMA will not apply to them. So if you see a fund, although they are not very common, but if you do see an open-ended investment company, note that the fund manager can buy back the shares, or the company can buy back the shares held by those investors, and it will not be violating the provisions of CAMA, provided that that open-ended investment company is duly registered with the SEC. Now, you hear open-ended scheme versus closed-ended scheme. An open-ended scheme is a fund that continuously creates and issues units. So what you see in collective investment scheme, the terminology used for the instrument issued by the fund manager is units, as opposed to shares. The only instance where you find shares is where you're talking about an open-ended investment company. For other funds that are collective investment schemes, they issue units. For open-ended funds, they continuously create and redeem the units. They buy back, the fund manager can buy back. The pricing for the buyback is set out in the SEC rule and is based on the net asset value. Now, for closed-ended funds, you cannot issue additional new units. So I set up a closed-ended fund and I issue 1 million units. Those 1 million units are the units that I am going to issue. I am not going to issue additional units. If you want to sell, unlike an open-ended fund where the fund manager will buy back, depending on whether the cash and the pricing will buy back from a unit holder. For closed-ended funds, I can only trade through my stockbroker. So if nobody is buying, then I cannot exit. And I do not issue additional units at will. Now, so that's the difference. Then you have the concept of interval fund. I mean, to the best of my knowledge, there's only one interval fund in Nigeria. What the interval fund does is that the fund manager is able to buy back in a closed-ended fund periodically. It will tell the unit holders, oh, I want to buy back during this period or at this price. It will give them the sufficient notice and then they can buy back, because the reason why the interval funds are structured this way is just to provide some liquidity. Then you have, there's always a question of whether unit trusts are different from mutual funds. From a Nigerian law perspective, there is no difference, in the sense that even in the SEC rule, that's why I put this link here, they refer to mutual funds as unit trusts. Unit trust is a defined term in the ISA, not mutual fund. But in practice, the SEC would use mutual funds interchangeably. Now, in some jurisdictions, mutual funds are different from unit trusts in some jurisdiction, but under Nigerian law, there is no distinction in the technical sense and from a regulatory perspective. Now, the key parties to a unit trust scheme, you'll find the fund manager, the trustee, custodian, and the registrar. And the key documents are the trust deed and the custodian agreements. Now, so we are going practical now. In structuring a capital market transaction, the first thing every capital market lawyer needs to know and needs to ensure is that there is due authorization. Authorization is critical to the validity, and it is usually a disaster where a capital market transaction is not duly authorized. I'll give two life examples. One, my personal experience, one experience with another colleague. When I started capital market transaction, my first transaction that relates to preference shares was, I think it was in 2006 when I joined the firm. And the bank was going to issue preference shares. And the class, they had passed the resolution at the shareholders meeting to issue preference shares, but they did not create that class. And if the class of shares, if you don't have that class created, there's nothing to issue, right? So it was really bad, and we realized later in the day, and it was around this period where it was festive period, and the company had to convene an EGM and get the shareholders to create the class of shares. We register that class, the preference shares, before the transaction can happen. You also have a situation where you are doing a bonds transaction and the borrowing powers of the director the board of directors, they have limited borrowing powers, and your client has passed the board resolution, only for you further down, or when you get to SEC, you see that their borrowing power is unlimited, is capped. And so they cannot authorize the transaction. So the first thing you need to check as a capital market lawyer when advising on a capital market transaction is whether the authorization is there. And in checking the authorization, you need to review the memorandum and articles of association properly to ensure that the resolution that you have covers the field. If the resolution does not cover the field, then you need to quickly advise them to get the resolution. If like in my own case where the class did not exist, you need to advise them that that class of shares or the class of instruments they want to issue must first be created before it can be offered, because you can't offer what does not exist. So again, like I said, like I described, most articles empower boards to exercise borrowing powers, could however set a borrowing limit above which shareholders' approval must be obtained. So you need to carefully read through. And where the threshold or the trigger for shareholders' approval is something that requires the client to confirm, because for some public companies, it will provide that directors can raise capital for as long as they don't exceed 3 times total reserves of the company, less any existing debt. So you need the company to confirm what their existing reserve is. You need the company to confirm what their existing indebtedness, what it is. And then after you have subtracted that, you'll be able to determine whether there is still sufficient headroom for the directors to pass the resolution, or if a resolution of the shareholders will be required in order to authorize the transaction. And remember what I said about Section 142 when it comes to equity issuances. At least until that section is amended with regards to public company, if you have a client that wants to do an equity transaction and they want to offer shares to either do a private placement or do an offer for subscription, then you need to highlight Section 142 to them, because Section 142 requires that they offer all of their shareholders first before they can offer to that investors. The shareholders resolution is typically drafted to ensure flexibility. Again, as lawyers, we must see ourselves as problem solvers and not just identifying a problem. So when you are drafting a resolution, board resolution, shareholder resolution on authorization, it's very important that you draft it as broadly as possible. So I'll give an example. A company comes to you to say, oh, we want to issue bonds. Please draft resolution for us to say we want to issue bonds. As a lawyer, when you are drafting, you need to remember that the company can talk about bonds now, but I mean, as a transaction exigency requires, or maybe when they start speaking to the banks, there may other forms of securities may come up. So instead of just using bonds, you can use instruments, because like Moshood said when he talked about Islamic finance, Sukuk, for example, will not qualify as bonds. So if your client wants to issue Sukuk later or as part of the transaction or shortly after the transaction, and you have limited your resolution to bonds, it may not suffice, and you will be required to pass another resolution, which the clients will not find funny if they have to convene another meeting. So when you are drafting, draft as widely as possible within the ambit of the law, but ensuring that you provide flexibility. And that's one of the difference of value you can bring to the table, because when the client now looks at the resolution later, if they decide to do something else, you will also be very proud to say, oh, that resolution that we got at the shareholders meeting was broad enough to allow us issue both Sukuk and conventional bonds, and we do not need to convene another meeting of the shareholders. Now, sometimes the content of shareholder resolution is determined by the regulator. If you are advising a public company that is doing private placement, the SEC rule specifies what that resolution should contain. So you don't just draft the resolution like any other resolution. You need to be mindful that the SEC rule requires that you state the number of shares and you also state the price. And the reason is that the SEC is saying that a private placement has a dilutive effect. So shareholders that are in the company should know the price at which you are selling. It may not be possible for you to put the price, particularly if price has not been determined or if price will be determined via book building. So, but there are ingenious way of drafting that resolution. But you should be mindful, because I worked on a transaction like 3 years ago where what the client wanted to do was private placements. And one of the requirements of SEC rule is that it should be a special resolution. They had convened a meeting and they obtained an ordinary resolution of the shareholders. That was just an ordinary resolution to raise capital and did not meet the requirements of the SEC with regards to private placements. Now, we were advising the investor and we said, look, this resolution will not fly because these are the requirements of SEC. The issuer wasn't particularly happy, but they had to reconvene an EGM in order to get proper authorization. So you see that authorization is very key. Before you start drafting or doing anything, you need to be sure that the company is actually authorized to do what they intend to do. So this is just a nugget that most times you don't leave it to the company secretary to draft. As the transaction counsel, if you are acting as transaction counsel, you need to ensure that you have an oversight over that resolution to ensure that it's properly drafted and complies with the requirements. Here is a snapshot of authorizations where the issuance of debt is by sovereign or the state. SEC approval is not required for FGN issuances. Please note that it's in the ISA. However, the ISA regulates issuances by state governments and agents and wholly owned companies of federal governments. They are also required to obtain SEC approval. Now, so these are the additional requirements. Most of these are from the DMO external and domestic borrowing guidelines. Like I said, if you are working on an issuance by a state government, you need to read the DMO external and domestic borrowing guidelines. Don't assume that the guidelines is just for federal government. It also regulates issuances by state governments and their agencies. Then engagement letters. So engagement letters will set out scope of work and all of that. Then legal due diligence. This is another thing that as lawyers, we need to pay a lot of attention to. Remember, we talked about the authorization. If you're advising as transaction counsel, you will need to properly diligence. If it's an equity transaction, if it's a debt transaction, as transaction counsel, you need to do due diligence. You need to identify that the company is in good standing in terms of its filings, in terms of its authorizations. You need to check contracts. Now, material contracts. In the ISA, the definition of material contract is contract entered into outside the ordinary course of business in the last 3 years. However, in 2015, SEC amended the rules and they broadened the scope of material contracts. So please note that when you are doing your due diligence and you are defining or you are trying to guide the client on the scope of material contracts that require review, you should take guidance from the rules and regulations of the SEC on this. A lot of times, I've worked on transactions where people forget that it's now the last 5 years and no longer 3 years that you have in the ISA. So they limit the scope, and you would have to tell them that, well, when you read the accounts, you saw that the company has entered into additional contracts of this contract are still subsisting. In order for you to properly do your due diligence, you need to ensure that you comply with the definition of material contracts. You have litigation due diligence, you have regulatory approvals, and then there are also things on related party transactions, which the SEC rules now require you to disclose. So this I'll now go into an overview of the stages involved, key stages involved in capital market transaction, the issuer decides to raise funds via capital markets. They pass the requisite and board resolution or shareholders resolution. They appoint advisors. They prepare or review offer documents by professionals. The documents are submitted to the different regulators for approvals. And then depending on where it will be listed, if it's going to be the exchange or the FMDQ, there's a listing, and then there's a completion meeting or signing ceremony. Before 5 years ago, SEC insisted on parties holding what is called completion board meeting, where all the advisors, all the directors of the issuer will come, people will sign, take pictures, and do all sorts. But I mean, so these days, the signing ceremony, particularly with COVID, so you just go in, sign, and go back to your office. So what you have now is completion signing ceremony. It may not be a formal meeting, but parties just go to sign, and we are gradually moving away from the concept of completion board meeting that requires the board of the issuer to also be present. Now, book building opens. Remember that we described the book building structure. If it's a fixed offer structure, what you will find is application list opens. And I mean, so if you look at the MTN transaction, which is an ongoing transaction, the first phase, they did a book building to HNIs and qualified institutional investors, and a price was determined. That price is now what is being used for the retail offering. So it is a combination of two methods. The pricing was determined through a book building where the qualified institutional investors and the high net worth investors participated. When that price was determined, and a retail offering is now ongoing, and that retail offering is fixed price at 169 naira. That's which is the price that was derived from the book building process. So where you have a transaction that involves retail offering, because under the SEC rules, retail investors are not allowed to participate in book building, because the expectation is that you need to be savvy to understand the numbers and to understand a lot of things in order to responsibly price the security. Now, so after the book building will close, application lists will close. If it's a fixed offer offering, you collate subscription and then effect allotment and make necessary returns to the SEC. If there's excess subscription money, so it means that if you have more people subscribe than the number of securities available, you will need to return the money. Although the SEC rule allows you to take up to 15% of the excess and return the rest to investors. And then the securities are now properly settled. I mean, you get it either in your CSCS account, because we've moved away from paper certificates, and securities are now dematerialized in the sense that we no longer have paper certificates and the securities are listed. So that's a snapshot of what obtains the processes and the stages involved in a capital market transaction. We go into the professionals, and I'll pay more attention to the lawyers than other advisors. Now, it's very, very important as lawyers that you identify your role on a transaction, and that role will determine what you do. Now, in a bonds transaction, you will typically find three sets of lawyers. You will find the issuer's counsel, referred to as solicitors to the issuer. You will have the solicitor to the transaction, also called transaction counsel. And then you have the trustee counsel, which the SEC has said is not provided for in the law. But the reality is that in a debt transaction, the trustee counsel is really the most important, because the trust deed is the most important transaction document in a debt transaction. So if you are acting as issuer's counsel, you would review and ensure that the resolutions are in place. You will review the MEMAT. I see that in a number of transactions where people act as issuer's counsel, they think that it's less work. It's actually not less work, because you need to ensure that the issuer is ready for the diligence that will be done by the transaction counsel. So you need to prepare your client for the transaction. and for the diligence. So you will review the resolutions. You don't wait for the transaction counsel to come and tell you that, oh, this resolution that you gave me was not properly drafted. You should review before the transaction counsel does its own due diligence. You advise the client on regulatory approvals required. You assist with due diligence readiness. And in some cases, you draft prospectus. Drafting of prospectus is something that lawyers, I think in Nigeria, we've allowed issuing houses to really take this away from us. In international transaction, the issuer's counsel will draft the prospectus, because the prospectus, as we'll go into that when we are done with the rule, is a disclosure document and not just a marketing document. And so to the extent that it is a disclosure document, it means that it should be a legal document. But we have left that rule either deliberately or carelessly to issuing houses in Nigeria. I'm hoping that as the market evolves and we have more lawyers participate in capital markets, we'll be bold enough to take this work stream from the issuing houses as it's done by lawyers in international markets. I have never done a capital market transaction internationally where the banks draft. They run away from drafting because they don't want to be responsible for disclosure. You have publicity guidelines. What publicity guidelines are guidelines that would want for a company that is a publicly listed company. You have what is called price-sensitive information, which is information that is not known to the public, but if known, may affect the price. So when the board decides or takes a decision to raise capital, it is a price-sensitive information until it is disclosed to the public. Now, you should not go about talking about the transaction or doing certain things that may impact or suggest that you already have a transaction in place and you've not yet obtained regulatory approval. So the publicity guidelines, particularly for international transactions, will determine what can be said, how it can be said, and when it can be said before the transaction is known to the public. And even after the transaction is known to the public, before the transaction closes, what the issuer can say, how the issuer must say it, and what the issuer must not say is set out in the publicity guidelines. Again, this is a legal document that as lawyers, we must take responsibility for it. Now, the issuer's counsel will also review and will review transaction documents like the vending agreement, all of which we'll go into in subsequent slides. So in a nutshell, issuer's counsel wants to get the issuer in good corporate standing, ensure that all approvals and authorizations are in place, and see due compliance with all legal and regulatory requirements. Transaction counsel, which is what we all like to be called, is the solicitors for the issue, provides structuring advice. Where a special purpose vehicle is required, the transaction counsel will sometimes incorporate or let the issuer's counsel do that, will draft prospectus in some cases, will conduct due diligence. So the transaction counsel has responsibility for due diligence, has responsibility for the content of all the documents. And so gone are the days where you say you're a transaction counsel and you not review the prospectus very well, because the SEC now requires transaction counsel to execute a checklist called prospectus checklist. And then you also have the trust deed checklist. In that checklist, the checklist sets out the requirements of the SEC with regards to what the prospectus should contain. And as transaction counsel, you will be attesting to the fact that the prospectus or the trust deed contains all of this. So it means that you need, if you're acting as transaction counsel on a transaction, you need to pay attention to the prospectus. You need to ensure that the issuing houses or the lawyer drafting, if a lawyer is drafting, draft in consonance with the rules and regulations of the SEC. Otherwise, once you sign or execute that checklist and the prospectus is not in compliance, then you have the liability, right? And SEC will even return the checklist and say that certain things have not been set out in the document. So in a nutshell, transaction counsel wants to ascertain corporate standing, authorizations are in place, and that the requirements of all the resolutions meet all requirements, and everything that requires to be filed has been filed. Now, trustee counsel. Again, whereas in an equity transaction, you will have just the issuer counsel and the transaction counsel. In a debt transaction, there is a third layer, or in most debt transactions, you have a third layer, which is the trustee counsel, also generally referred to as the solicitors to the trustee, that will draft and negotiate the trust deed, advise on repayment structure, preparing the trust deed. Now, when you are advising as trustee counsel, please do not sit back and allow the issuer to determine what they want to have in the document. Because as trustee counsel, the trustee is relying on you. And remember that the trustee owes a fiduciary obligation to the bondholders. So they need you to provide the requisite guidance. You need to draft the document in a way that protects the interest of the bondholders while still achieving the commercial objectives of the client or the issuer. So you don't take instructions. If you're acting as trustee counsel, you don't take instructions from the issuer, because you're not protecting, you don't have the same interest at stake. You take instructions from the trustee. You ensure that you provide the trustee with the requisite guidance, because sometimes you see the trustee will just be saying yes, 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 but they are looking up to you as the lawyer to guide them in drafting the trust deed and in preparing the trust deed checklist. So the solicitor to the trustee will prepare the trust deed checklist, but the solicitor to the trustee is not the one that executes to say that it's in compliance with the requirements of the SEC. That is done by the transaction counsel. So again, in a nutshell, trustee counsel wants to ensure sound and security trust structure, tight reps and warranties by the issuer, ensures that the trustee is well indemnified, enforcement and realization of security can occur without recourse to issuer, and generally that investors' interests are protected. So when you're acting as trustee counsel, you need to have these 5 things at your fingertip. Then the issuing house, they are the guys that have practically taken over a number of our work. They are usually referred to as the lead advisor. They coordinate the activities of other advisors. They determine pricing with the issuer. They prepare offer documents most of the time. They file documents with the SEC. They coordinate pre-marketing and formal marketing of the offer, and then they prepare allotment proposal for consideration and approval. And they also ensure that the issuer gets the offer proceeds. You have the auditors that will audit the accounts. You have reporting accountants. Reporting accountant, again, is something that is peculiar to this market. What the reporting accountant does is to review the audited accounts and then give a report based on their own review of the audited accounts. In international transactions, it is the auditors that review it. They go through a tick and tie process and then they issue their opinion. But in Nigeria, you need to employ or engage the services of different sets of auditors referred to as reporting accountants. Even though they are professional auditors, they review the immediate past 5-year audited accounts of the issuer. Then you have the stockbrokers. They list securities on the exchange. They introduce the company to quotations committee, and then they are the liaison between the company and the exchange. You have the receiving agent. Those are the guys that collect application forms. You have the receiving bank. They are the custodian of the offer proceeds, and they remit to the issuer. Where you have issuing house can double as receiving bank. This will only happen where it's a merchant bank that is advising, not a commercial bank, in view of the CBN requirements. And then you have the registrars. They receive application forms as well. They update the register. They liaise with the CSCS to ensure that the register is properly updated electronically, and they dispatch certificates. However, even though this is a regulatory obligation with regards to dispatch of certificates, like I said earlier, we have moved to dematerialization, where we no longer issue paper certificates and everything is done electronically. We have the CSCS and the FMDQ clear. I talked about these ones when we discussed clearing system. You have the FMDQ depository. Recall, we talked about depository and I said we're not paying too much attention to that one here. Now, these are the basic transaction documents you'll find in a domestic capital market transaction. You have the prospectus. The prospectus can be a shelf prospectus or standalone. Now, in a shelf prospectus, you have a shelf prospectus where you are setting up a program and you are undertaking a shelf registration. So I'll try to break it down. As an issuer, I can decide to set up a program that allows me to raise money from the capital markets over a period of 3 years. I prepare this document called a shelf prospectus. And you know, the way when you say that something is on the shelf, I will prepare it and put it on the shelf. And each time I want to raise money within that period of 3 years, which is the period that the SEC allows before you can apply for a renewal, I would issue a supplement where I would only be updating anything that has changed. So where you see shelf prospectus, it's a document that is very bulky. It says everything about the issuer. It talks about the different types of instruments that can be issued under that program and allows the issuer to raise capital, issuing the different type of securities within that period specified, the validity period. Now, the prospectus could also be a standalone, where the issuer decides not to set up a program. I just want to raise money once and sit down and see how the market looks like and decide if I want to go back again. So it can be a standalone, and in that case, it is just called prospectus and not a shelf prospectus. The shelf prospectus is applicable in a shelf registration requirement where that meets the requirement I described earlier. Another type of prospectus that you would see is what we refer to as the Red Herring Prospectus. Recall that when I was talking about book building, I said that a prospectus will be issued to the investors that says everything about the company and has everything apart from the price. That prospectus is called Red Herring. So it's the prospectus that investors will read. They will read upon the issuer in that prospectus and then give a price range and build their order book based on that. So primarily, you have 3 types of prospectus in the domestic market. You can have the shelf prospectus. You have the standalone prospectus, which is your regular prospectus. It's not called standalone, it's just a prospectus that is issued in a non-program transaction. And then you have a Red Herring Prospectus, which is applicable if you are doing a book building as the method for discovering price. Now, if you are doing a shelf registration, you issue that shelf prospectus. Each time you want to raise capital, you are not expected to prepare another bulky prospectus. Rather, you prepare what is referred to as a pricing supplement. That pricing supplement will set out the terms and conditions applicable to that instrument you are issuing, and it will also set out the price, the duration, if it's a bond transaction. So you will find a pricing supplement in a transaction where there is a shelf registration. So it is not in all transactions that there will be a pricing supplement. You will only find a pricing supplement in a transaction where what has been done or what is being done by the issuer is to set up a program that allows it to issue securities over a period of 3 years, anytime it thinks that the market is good enough to take up its investment. Then you have the trust deed. The trust deed is applicable to only bonds transaction. And in collective investment schemes, you also have the trust deed. The trust deed, unfortunately, the SEC rule does not really specify what should be contained in the trust deed for a bonds transaction, but you have the trust deed checklist. So when you are drafting your trust deed, you need to take the trust deed checklist issued by the SEC and use it as a guide to draft. Again, remember that you must check the provisions of CAMA that deals with contents of the debenture trust deed when you're drafting your trust deed for a bonds transaction. The trust deed for a collective investment scheme is largely regulated by the SEC, and the content you will have specified in the rules. Then you have the vending agreement, which is the agreement between the the agreement between the issuer and the issuing houses. From the word vend, it means that's the agreement that authorizes them to sell the securities. That's the agreement they sign in order to engage the SEC on behalf of the issuer. The SEC rule contains there are certain clauses in a vending agreement that are set out in the rules and regulations of the SEC. So for example, the dispute resolution clause in the vending agreement, you cannot just import any type of dispute resolution clause in a vending agreement because the rules specify what the dispute resolution mechanism should be. You also have your litigation and material contract opinion, and then the rating report. So like I said, when we're talking about the rules, that the SEC rules prescribe the content and in some instances, the form or format of the provisions of some of these documents. So I've described the prospectus is both a marketing and disclosure document. I've talked about the shelf prospectus, I've talked about the pricing supplement, and I also talked about the Red Herring Prospectus. And it must contain detailed and accurate statements of all relevant information. On the cover page, the SEC also says what should be on the cover page, including the fact that directors are liable for every misstatement that is contained in the prospectus. However, SEC has found a way to rope in the lawyers because statutorily it's not the issuer and the issuing houses because they are the ones that draft. But with the prospectus checklist that SEC has introduced, lawyers also have to attest to the accuracy of the information in the prospectus. So again, I want to reiterate, if you're advising as transaction counsel on a deal, please don't just flip over the prospectus and say that it has so many numbers. You please read, ask questions, make your comments, and if those comments, you feel strongly about it, please engage the issuing houses. The trust deed, like I've described earlier, is a document between the issuer and the trustee. There's a difference. So you also have the program trust deed and the series trust deed. The program trust deed is similar to the shelf prospectus. It's a trust deed from the name program. It talks about if you are setting up a program where you have a shelf registration, it talks about every type of instruments that you can issue under that program. It's usually a bulky document. And then for each series, each time you want to raise capital, you will prepare the series trust deed, and the series trust deed will only set out the terms and conditions applicable to the instrument you are seeking to issue under that structure, under that tranche. And then I put a note there that the content of a trust deed for a bond is different from that of a collective investment scheme. And also the parties to collective investment scheme trust deed are usually the fund manager and the trustee. So I've described the vending agreements as the agreement between the issuer and the issuing houses, pursuant to which the latter will vend the securities. It sets out the obligations, the cost and expense, payments, reps and warranties, and all of that are set out in the vending agreement. Like I said, it talks about the reps and warranties that the issuer will give to the issuing houses because they are the ones marketing. They want to ensure that they have sufficient reps and warranties by the issuer in their favor. And then you also have the covenants of the issuing houses. I put them on. If you look at the fourth bullet point, act with prudence, diligence, and in good faith, and utilize best endeavors. Most issuing houses will push back and say that they want reasonable endeavors. Again, it's a naughty provision, so be mindful when you are reading, particularly when you are reading as issuers counsel, because it would have been drafted by the transaction counsel. And then indemnities in our markets, and depending on who you are advising, the issuers will typically insist on having reciprocal indemnity. For most international transactions, banks do not give indemnity to the issuer. But our market is still developing, and issuing houses are beginning to push back on indemnity being provided, on their obligation to provide indemnity to the issuer. And they insist that if they fail in their obligations, then the SEC, you have recourse under the SEC rules. It's neither here nor there, but just so that you should be mindful in case you're working on a transaction where an issuing house is pushing back and saying that I'm not going to give them a reciprocal indemnity. So that takes us to the end of the slides. I will take questions now.
My Aziza, my. Anyway, I reserve my comments for after question time. But brilliant, absolutely brilliant. I don't think anybody that's assisting me can access the questions. So let me see where we are. So let's see. So I think the first one there is, I have Basirat Rahim. She says, what is the major importance of issuing a zero coupon bond against issuing an interest-based bond?
Okay, so zero coupon bond, like I said, is really the fact sometimes if I'm an issuer and I've determined my cash flow and I see that I may not have sufficient cash to make up my periodic coupon payments, I may want to structure it as a zero coupon bond, knowing fully well that at maturity, I would be able to repay everything. So from an issuer perspective, it could be an incentive to issue the bonds. Now, some argue that some people do it to meet up. If you are issuing securities in markets where your investors may not want a coupon-based generating instrument for either ethical reasons or religious reasons, you may also want to consider zero coupon. So I'm not sure if that answers the question. It's usually from a point of view of, and then the third reason why we think about it sometimes is for tax reasons. Because there is no interest payment, there is nothing that is subject to withholding tax. Now, when you make that gain, there is the risk that it will form part of your taxable profits, and the taxman can still, at that time, determine that you pay interest on it. But at the time where the issuer is repaying you the full value at maturity, there is no obligation to withhold anything because it is not interest. So I hope I've been able to do justice to that question.
Yes, indeed, Aziza. I was just thank you for that. As a comment just made me laugh. Some chap said these things are damn complex, but that's fine. So going back to the questions, an anonymous attendee says, how can a lawyer register as a capital markets operator?
Okay, so the SEC has a requirement for registration as capital market operator. There's a form, and then you go through a training process, and then you write exams, and you do an interview. So that's a summary of the process as set out in the rules. So I think it's also available on their website if you require additional information. So you get the form, you write the test, and you go for the interview.
Okay, so the next one is, could you please explain the concept of appointing a price stabilization partner? I believe you called it Green Shield. Okay,
so I said that it's a new rule. It's quite complicated. I don't even know why I put it on the slide because it's, it's very complicated. It's a process that you use to, like I said, so if you have too much demand or too much supply and you want to adjust your price, you appoint a stabilization manager. The exchange has rules on the process for appointing and who can be the stabilization manager and the duration for the stabilization. I will advise that the person tries to read up on the rules, because if I describe it, it may get complicated. I am available via email to respond to any question you may have after you have read the rules. But the first thing is to read the rules. It's on the website of the exchange on stabilization. And I said the alternative name is Green Shoe. It's called Green Shoe in most jurisdictions because the first company to use it is a company called Green Shoe Company Limited. So please read up on the rules. You can get my email address from the organizers. And if you have any question after you've read the rules, it will be easier to have a conversation at that time.
Thanks a lot for offering up your email address to this particular person, not to the world at large though. So we have another one. Says, Ma, thank you for the presentation, really. You stated that there are things that a capital market document must contain for a particular transaction, in light with the numerous rules and applicable laws? Is there a way or like a list to check what must be in the document, or do we go through the documents every time?
Okay, so with the prospectus, thankfully, like I said, SEC has issued what is called prospectus checklist. So what I usually advise associates to do is that when you are reading, because of the way the rules are drafted, ideally, before checklist, what I used to do and how I got familiar with my rules is I just try to familiarize myself with the rules that relates to prospectus, not everything, before I start reading. However, that can take a lot of time and can be tedious. Now, if you take the checklist gives some guidance, because the checklist refers to the specific rules and what you are meant to have in the prospectus. So for your prospectus, if you are reading, the first thing you should do is to download the SEC prospectus checklist, such that when you go through the table of contents or as you are reading page by page, you are using that checklist to ensure that they have put everything that is required, because that is the checklist that SEC will use to tick the box. So that is that for prospectus. And it is also helpful for trust deed, because you also have the trust deed checklist. However, for vending agreements, if you are drafting for the first time, I will advise you, in order to do a good job, give your senior a good first draft. Please go to the SEC rule on vending agreement. It is not very lengthy. It used to be 278. I can't remember the number now. You will read it and understand what you are meant to have in there. Once you do it 2 or 3 times, you can draft the vending agreement even if you are sleeping, and you can comfortably negotiate. But when you are learning, the first 3-5 vending agreements you will do, please just always go back to the rules to be sure that, oh, this thing should be there, this thing, and then it also helps you to negotiate. Because if you're not familiar with the rules and try to understand why those provisions are there, when issuing houses push back, you will readily give up because you don't understand why it's there. You just know that it's there because you've used the template. So it's very important as a capital market lawyer to read and understand the reason why certain things are put in the document. It is tedious. Like I said at the beginning, capital markets it requires a level of passion for you to do it very well. Because when you think of the rules, when you think of the regulators, you just want to give up. So, but it's not that bad. By the time you do it over time, 3, 4, 5 years, you'll be so familiar with it that you are only freshening up what you've read as the new rules evolve, right? And those new rules, you are just going to be understanding the basics, not that you are reading from the beginning.
Thank you very much. And in respect of also anonymous attendee, in respect of dual listing, how does a Nigerian firm list on NGX and then on the London Stock Exchange? Example, and what assets are linked to such listings, and how does dividend payment work?
Okay, so Orlando has a dual listing on NGX and GSC, that's the Johannesburg Stock Exchange. And so it's the same company with shares listed. The way the Orlando works, if I recall, so I don't give wrong information, I know that they have certain shares listed on the GSC. In terms of dividends, they will declare the dividends in Nigeria and repatriate the dividends. There's a register. I think they used to use CompuShare. I don't know who the computer warehouse. I don't know who they still use. The dividends will move through that entity who will distribute on their behalf. Because it is income that is derived from Nigeria, it's still subject to withholding tax under Nigerian law. What they have listed there are the shares, and the trading in those shares occur on the GSC and doesn't impact what happens. I mean, so say for pricing, it doesn't necessarily impact what happens on the Nigerian exchange, because there are 2 exchanges with 2 separate registers and 2 sets of shareholders.
Okay, so the next person says, please clarify on depository receipts again. It was not clear. Thank you.
Okay, so depository receipts are instruments that evince ownership in underlying instruments such as shares in most cases. So like I said, when Nigerian companies try to list abroad, there are requirements, particularly on the LSC, that you may not be able to meet. And even if you're able to meet the requirement, you realize that some investors have constraints coming. So you will engage a depository and allot, say, 100 shares to that depository. Based on pricing, the depository will decide whether the 100 shares represent 50 depository receipts. The depository will issue the depository receipts to the investors, but the beneficial ownership of the underlying shares, such as the rights to dividends, will accrue to those depository holders, but their names will not be entered in the register of members. So when the Mr. Company declares dividends, it will give the dividends to the depository, who will be the shareholder on record. Depository knows that, oh, I issued 10 depository receipts to 10 guys, and I'm going to give them dividends. I'm going to distribute these dividends based on the number of depository receipts that they hold. That depository receipts, 2 depository receipts will translate into 4 shares, and then they will get dividends equivalent to what they would have obtained if they were holding the 4 shares directly. So it's an indirect ownership. So even when it comes to voting, the depository will receive notice of meeting and take instructions from the depository receipt holders. And then based on that instruction, will vote at the meeting. So the depository is just like I don't want to say pass-through, but it's like a pass-through that is in the register and is holding on your behalf, but it's also giving you something that you can trade to show that you have beneficial interest in certain underlying instruments that will be set out on the face of that depository receipt. So I can trade my depository receipt, and in ownership of the underlying shares still remains, the legal ownership remains in the depository. But once I trade, the beneficial interest will go to that holder of my depository receipts. I don't know if that person is satisfied now.
There's no way to find out, but I think there would be my own view. Thank you. I don't know how you're doing for time. We'll have a few more questions. And because I think they really, there's a lot of interest in this, I'll just run through them quickly, please, if we can.
Okay.
So, are private equities part of collective investment scheme? If so, what type of CIS are private equities?
Okay, so SEC has specific rules on private equity funds. So if you want to structure, they've not necessarily called them CIS, but they do have there are certain private equity. I think if you miss the threshold of 1 billion naira or something, then you will need to register with SEC. So again, if you're advising on a transaction that is private equity and you want to determine whether or not it requires registration with SEC, you need to check the SEC rules because there are requirements of private equity, but the trigger is 1 billion naira. That becomes mandatory unless, of course, you want to register because you want PFAs to invest in you. So you just want to register on your own volition. But there are rules on private equity in the SEC rules.
So how is the market treating Section 142 of CAMA 2020 on preemptive rights for public companies? Also, what are the differences between the preemptive rights rule in CAMA and the rights issue in the SEC rule?
Okay, so I don't know how the market is going to deal with that Section 142. I mean, we are working on a transaction now where the issuer has just said, I'm going to offer my shareholders first. If they participate, fine. If they don't participate, I will know that I've complied. So people have devised means of, if I do a scheme of arrangement, I get my shareholders to pass a resolution under, I think it's 715 or 711 of CAMA. I do a scheme of arrangement and shareholders will decide that they want to waive that right. That is a legal possibility. Whether it can be challenged or will be challenged is a different conversation, because like I said, preemptive rights are personal rights. And so a mischievous shareholder can say that you cannot use a 75% presence and voting to take away my rights. You cannot use a court sanction to take away my rights. But whether we'll get to that era or not, nobody can tell yet. But so the two options being considered, if you have the appetite, you go through offering your shareholders. If you don't have the appetite, or you think that your shareholders is going to be a waste of time, you take the risk and do a scheme of arrangement where your shareholders will agree to waive that right. But then when you advise clients on that option, you need to let them know that that is the option that is being discussed in the market. Whether shareholders will challenge it or not, it remains untested in court. Now, the other question was on the difference in the right. I'm not sure I understand the question, but the preemptive rights that you had in CAMA, that we have in CAMA now, is mandatory and applies to all private companies and public companies. Before now, the SEC did not provide for preemptive rights. The SEC regulates private placement and only says that if you are doing a private placement as a public company, you need to get a special resolution from your shareholders and also let them know the number of shares you are offering and the price at which you are offering it. However, pre-CAMA 2020, public companies, usually some public companies have the language in their memos to say that unless otherwise resolved at a general meeting, the directors before issuing shares must issue shareholders first. Because that says that unless otherwise resolved at a general meeting, it means that there is a process for you to convene a meeting of your shareholders that will approve a transaction and indirectly do away with the preemptive rights obligation. That was the regime before CAMA 2020. The trading of rights that I discussed on that rights issue has nothing to do with preemptive rights. When you trade your rights, I said that in a rights issue, there is a provisional allotment. And from the word provisional, it means that it's subject to certain conditions being made. So there's a provisional allotment of shares to a shareholder in a rights issue based on their existing shareholding. That right that you have, that provisional allotment, can be traded on the exchange to an investor. And it is a mechanism that investors use to get into a company that they would otherwise not have been entitled to participate or get shares, right? So it is separate. It is not a preemptive right. It is that I have rights that I have been given as a result of the rights issue. And I've decided that rather than take up the rights, I want to trade them.
So can governments or subnational authorities create bonds through private placements?
Okay, so again, so for federal government, remember that I said that they don't need SEC approval, so they just need to comply with the requirements of the DMO external and domestic borrowing guidelines. That's for federal government. Now, for state government and state government agency, the provisions of ISA says that they can only raise money from the capital markets through the process set out in the ISA. There are different, when you see this transaction, there are different school of thought as to what constitutes the Nigerian capital market, because unfortunately it's not defined in the ISA. There's a school of thought that says that where the state government does a private placement to an identified investor, say 2 or 3, they are not raising money from capital markets, and so they are not meant to comply with the provisions of the ISA. There is another school of thought that says that because SEC rule, and the catch is that under the SEC rule that talks about registration of securities, it says that securities of state government must be registered with SEC before it can be issued. So the question becomes, you have an obligation to register the securities, but we are saying that it is not capital markets. So when you go to SEC to register the securities, what will you say you are doing? And so it's one question that remains unanswered, because we've tried, B and I as a friend, we've tried to engage the SEC on that fine point before, and we never got a response. Because we've said, okay, can I just come and register the securities with you? Because there's another rule that says I must register with you, but it's separate from the rule that says that capital markets, if I want to raise money from capital markets, then I need your approval. And SEC has not come out to say that, oh, you can do your private placements without, and I will not view it as capital market, but come and register securities with me. So theoretically, it is possible. Practically, and what it will entail, I cannot confirm, because the SEC has not taken a clear position on that.
Thank you very much. So I didn't quite get your definition of the custodian agreement. Could you please explain it again?
Okay, so I said that the custodian agreement, you have it in the collective investment scheme between the custodian and the fund manager, and I think the trustee is also a party, where the SEC has made it mandatory because they've said that they want trustees, even though trustees by the trust deed have an obligation to segregate the assets of the fund from their own assets. The SEC has said that the title documents and everything that is acquired should be deposited with the custodian. And in terms of cash, the resource and everything, the money should be regulated by the custodian. So the custodian agreement is an agreement between the fund manager, the trustee, and the custodian that ensures that the custodian has like an oversight or overview over the assets of the fund, and those assets are segregated from the assets of the fund manager or the trustee.
Well, thank you. This one is a funny question. You may choose to answer or not. So, gentleman, I'll call the name of the person because it's really a funny one. So, Owala Murphy Abeye, his question is, as a capital market expert, would you say MTN shares are good for purchase?
I cannot advise on that because the offer document says that you should get advice from your stockbroker or your bank or your lawyer, and I am not your lawyer for the purposes of the transaction.
Fantastic. Okay, then another anonymous attendee, what do depositories get in return? Also, is it possible they vote unfavorably?
Yeah, so the depositories are paid by the issuers. They are paid something by the issuer. And if the investors, sometimes they may also get commission from the investors, depending on the terms of the depository agreement. They cannot vote unfavorably because the depository agreement will provide for how they should vote and what happens if they don't get clear voting instruction. I've attended a meeting before where the custodian on behalf of the depository could not vote certain shares because they didn't get instructions on those shares. So in most cases, those custodians that represent a depository in the Nigerian companies would want companies to vote by poll so that they are able to exercise the voting rights based on the instructions that they get. And where they don't get instructions, they don't vote the shares. So the chances of them voting unfavorably, against the instruction of the depository holders will be very slim, and it will be breach of contract.
Thank you. Now this sounds more like a comment. So it says perhaps transaction parties can use a deed of waiver to get around the problem with preemptive rights.
Yeah, I mean, so a deed of waiver, it really depends on if you have 1,000 shareholders, where will you find to execute? If it's a publicly listed company, some companies have 3,000 shareholders in their register. Some have 20-something thousand shareholders. Where will you find them? It's a practicality. If it's a small company, yes, it may work, but
yeah. So the other one is, are private companies required to register their shares with SEC?
no, SEC does not regulate private companies.
Okay. So the final one is not really, doesn't fall under your topic, but let's see what you think. It says, in debt Islamic financing, what types of security can be created?
Okay. So, I mean, because I didn't follow, I wasn't there from the beginning when Masood spoke, but really, we don't call Islamic financing for the Sukuk, we don't call it debt per se. And like he said, the structure you are using, if it's an ijara, if it's a mudaraba or musharaka, it is the structure of the underlying assets that would determine the kind of security that you would have. So it's transaction and structure specific. So you cannot take what would have been applicable in an ijara and bring it to a murabaha, for example. So the structure of the underlying assets. Remember that for Islamic finance, it is interest you have ownership interest in the underlying assets, and it's not just that you gave money. So those underlying assets and whatever it is, and whatever structure you are using will determine what the security package will be.
So I think we'll come to the end of question time. I think we took another 30 minutes of your time. You offered us up about You offered up about 13 yourself, which was great. And because we saw that people were still here and interested, we just decided to take up the opportunity. But I must say, what an afternoon this has been. What an amazing afternoon. I mean, I must commend you for the style of presentation and for the time you took to explain every material aspect of the training. I mean, it's amazing, really, what you've done. Thank you very much. I mean, flowing from Masood to you, I'm sure that the participants, I mean, and the comments actually truly attest to how excited and happy they are. It speaks very well of this generation of lawyers, that people are really truly willing to give back and to share their experiences and their knowledge more than what we've seen previously in Nigeria. So I must thank you very much. I know how busy you are, and I know there was a mix-up in your earlier date, and you still agreed to do this today for the benefit of all of us in the bar. On behalf of the Nigerian Bar Association, I must say a huge thank you to you, and a big thank you to Masood, who is also still online. Thank you very much, very grateful. And I hope that when we call you again, and we will call you again, you will have the time to share your thoughts and ideas and knowledge with us. Thank you, and God bless.
You too.
Okay, so where are we? We're actually at the so we're supposed to finish today, but there'll be a spillover to tomorrow. So the flyers will be circulated. Guarantees and indemnities will be discussed tomorrow. For those who are interested, the training will start at 3 p.m. Thank you very much for participating. I'm also grateful because I can see El Fubara Anga joined in on the training. Thank you very much, Leonard Senior Advocate. So see you all tomorrow. God bless. Have a blessed evening. Bye-bye.
Thank you, and bye-bye.
Bye, Masood. I can see Ade Musoro. Ade, are you still here? Ade, are you still on board? Okay, now listen.